You arguing with me? The metal detector beeped. Camille Booker stood perfectly still, leather folio under her arm, hands visible at her sides. Behind her, 3 attorneys had just walked through the checkpoint. All white, all male. Dark suits, expensive shoes, briefcases with brass latches. The detector hadn't made a sound for any of them. Travis Mundy pointed toward a door off the main corridor. His finger jabbed the air twice. Secondary screening. Move. She followed him into a room with cinder block walls painted institutional beige. Fluorescent lights hummed overhead. A metal table sat bolted to the concrete floor. No windows. The door clicked shut behind them. Travis took her folio without asking, opened it, flipped through the contents slowly, reading case names, scanning highlighted passages. Legal briefs for Hughes versus Greenfield Properties. 12 tabs, color-coded. Every citation verified twice. What's this? You a lawyer? Law student. I'm here to file. Students use the law library entrance, not the main door. Camille's eyes moved to the sign mounted on the wall behind him. Black text on white laminate, official Durham County seal in the corner. She read it aloud, voice steady and clear. All persons entering courthouse facilities shall be subject to security screening without regard to race, color, or national origin, pursuant to North Carolina General Statute 143-422.3. Travis didn't turn to look at the sign. His jaw tightened instead. He stepped closer, close enough that she could smell stale coffee on his breath and see the razor stubble he'd missed that morning under his chin. You think you're smart? His right hand dropped to his belt. Not the radio. The other side, where the holster sat. His thumb hooked through a belt loop near it, casual but deliberate. What Travis Mundy didn't know, what he couldn't know as he stood there in his courthouse security uniform with 6 prior complaints buried in his personnel file, was that the woman in front of him had a photographic memory for case law, a Rhodes Scholarship, and a summer Supreme Court clerkship under Justice Sonia Sotomayor on her resume. He didn't know her father was Fourth Circuit Judge Roland Booker, author of one of the most cited civil rights opinions in recent federal case law. And he definitely didn't know that in exactly 4 months, she would file a federal civil rights complaint that would put his name, badge number, and every single one of those 6 violations on a federal judge's desk. But right now, at 2:47 on a Tuesday afternoon, she just needed to get past this checkpoint and file her emergency motion before the 4 p.m. deadline. The metal detector beeped again behind them. Another attorney walked through the main checkpoint. White woman, navy suit, clicking heels on tile floor. Travis didn't even glance in that direction. Stay here. He walked to the doorway and lifted his radio to his mouth. Spoke in a voice too low for her to hear clearly, but she caught fragments. Secondary. Individual. Asking questions. He looked back at her twice while he talked, each glance lingering a beat too long. When he returned, his expression had hardened into something colder. Empty your pockets. Shoes off. Jacket too. She complied without speaking. Set her phone on the metal table. Keys beside it. Black pen with Duke Law School printed on the side. Slipped off her flats and placed them next to the phone. Removed her blazer, folded it once, set it down carefully. Travis picked up a handheld metal detection wand from a hook on the wall, ran it over each item on the table with exaggerated slowness. Phone, keys, pen, shoes, jacket. The wand stayed silent. Not a single beep. Turn around. Earn. Arms out to the sides. She turned, extended her arms. The wand passed over her shoulders, down her spine, across her waist, lingering at her hips. When it reached her lower back, Travis stopped moving. The wand pressed against her spine, just hard enough to make her shift her weight forward slightly. What's this? What's what? This. He pressed the wand harder. Feels like something hard. That's my spine. His jaw worked like he was chewing something. The wand stayed pressed against her back for 3 more seconds before he finally moved it down to her waist, then her hips, taking his time with each pass. When he stepped back, She turned to face him again. "Am I clear?" "For now." She gathered her belongings, phone, keys, pen, back into her blazer pocket, shoes back on, jacket over her arm. When she reached for her folio, Travis picked it up first. "What else you got in here today?" "Legal documents for a case I'm filing." "Open it." She unzipped the folio. Travis pulled out documents one by one. Motion for temporary restraining order. Supporting brief. Affidavit from Mrs. Yolanda Hughes. Exhibits A through D. Certificate of service. He read the caption on the motion, lips moving slightly as he processed the words. "Emergency temporary restraining order. Sounds like you're trying to get special treatment." "I'm trying to prevent an illegal eviction." Travis held up the certificate of service, squinting at the notary stamp. "This real?" "Yes." He set the document back in the folio but kept his hand on it. "Good luck with that." She took the folio from under his hand and walked out of the secondary screening room. The metal detector in the main checkpoint didn't make a sound as she passed through it. It never had. The clerk's office sat on the second floor. Camille took the stairs instead of waiting for the elevator. Each step measured, controlled, while her mind cataloged every detail from the last 12 minutes. Travis's badge number, she'd memorized it from his uniform plate, 4792. Duration of screening, 11 minutes, 40 seconds according to the clock on the wall. 3 white attorneys passed through during that time. 0 secondary screenings. Her phone buzzed in her pocket as she reached the landing. Text from Professor Jamal Washington, her clinical supervisor at Duke Law. "How's the filing going?" She didn't respond yet. Wait until the clerk actually stamped the motion. Wait until it was officially filed. Then she'd tell him about Travis, about the secondary screening, about all of it. The clerk's office had fluorescent lighting that made everyone's skin look slightly gray, and walls painted in a shade of beige that seemed designed to inspire hopelessness. A long formica counter separated courthouse staff from the public. Behind it, 3 clerks worked at desks covered in stacks of files. One answered phones in a voice flattened by routine. Another typed with 2 fingers, hunting and pecking at a keyboard. The third sorted documents into color-coded bins. The woman at the front counter looked up as Camille approached. Her nameplate read, "Sharon Pruitt, Chief Clerk," in brass letters on fake wood grain. Sharon Pruitt, 52 years old, 18 years at Durham County Justice Center. Married to a construction contractor who'd won 3 county building projects in the last 5 years. Member of the Courthouse Employees Union Negotiating Committee. And, though Camille didn't know this yet, close personal friend of Elliot Chandler, senior city attorney. "Good afternoon. I'm here to file an emergency temporary restraining order in Hughes versus Greenfield Properties." Sharon's eyes stayed on her computer screen. Her fingers kept typing for another 8 seconds before she stopped and looked up. "Proceed?" "No, filing on behalf of my client through Duke Law School's clinical program." "You certified?" Camille pulled the student practice certification from her folio. North Carolina General Statute Section 84 to 4.1 allowed third-year law students to appear in court under supervision. The document had the state bar's seal embossed in the corner, Professor Washington's signature at the bottom, valid through May. Sharon took the certification and held it at arm's length, squinting. Read every word slowly. Turned it over to check the back, even though nothing was printed there. Finally set it on the counter. "We're backlogged. Come back tomorrow." The statute requires same-day filing for emergency TROs if submitted before 4 p.m. Camille kept her voice level. "It's 2:51. Sharon's expression shifted. Not much. Just a tightening around the eyes, a flattening of the mouth. She glanced at the clock on the wall, one of those institutional models with a black frame and white face, the second hand ticking in audible jumps, then back at Camille. "Honey, I've been doing this 18 years. You want to tell me how to do my job?" The word honey landed like a slap. Camille placed her filing on the counter anyway. The motion was 32 pages. Tab markers stuck out from the edges in rainbow colors. Red tabs for cases, blue for statutes, yellow for exhibits, green for procedural rules. 12 cases cited, 4 statutes, all verified at the law library yesterday, then verified again this morning. Not at all. I'm just following North Carolina Rules of Civil Procedure, Rule 65. Sharon pushed the papers back across the counter without looking at them. The motion slid until it hit Camille's hand. Missing a signature page. Can't accept it. Camille flipped to page 6, her signature in black ink dated that morning. Below it, the notary's stamp from the Duke Law Administrative Office with the notary's signature and seal. The date was clearly visible, October 10th. She turned the document around so Sharon could see it, said nothing, just let the evidence sit there between them. Sharon's eyes flicked down to the page for maybe half a second. Come back when you've practiced law more than 5 minutes. Behind Sharon, one of the other clerks, a younger man whose nameplate read Mitchell, glanced up from his typing. He looked at the document, then at Sharon, then went back to his keyboard without saying anything. Movement in Camille's peripheral vision. A woman walking past the counter, heading toward the elevators. Court reporter, based on her stenography case. She slowed when she heard Sharon's voice, turned her head slightly to see what was happening. Her eyes met Camille's for just a moment. Something passed between them. Recognition, maybe, or understanding. The court reporter's pace slowed even more as she passed, but she didn't stop walking. Camille pulled out her phone and opened the Notes app, typed while Sharon watched, each word deliberate. October 10th, 2:53 p.m. Clerk Sharon Pruitt refused emergency TRO filing. Claimed missing signature page. Page 6 present, notarized, dated 10/10. Witness, court reporter, name unknown, Clerk Mitchell. Sharon's face flushed. You recording me? Taking notes from my case file. Camille's thumbs kept moving on her phone screen. Is there a supervisor I can speak with? I'm the chief clerk. Sharon's voice rose slightly. There is no supervisor. The phone at the desk behind Sharon rang. 4 rings. 5. Sharon ignored it. Neither of them moved. The younger clerk, Mitchell, picked up the phone on the 6th ring, his eyes darting between Sharon and Camille. Camille finished typing and lowered her phone. Then I'd like you to formally reject this filing so I can note the specific grounds for my appeal to the Court of Appeals. The words hung in the air. Sharon's jaw worked. 10 seconds passed. 15. The overhead fluorescent lights buzzed. Someone's shoe squeaked on the tile floor in the hallway outside. Then Sharon snatched the motion from the counter hard enough that the pages bent. She grabbed the filing stamp from beside her computer, positioned it over the top page, and brought it down with enough force that the sound echoed off the walls. The stamp left a red impression. Filed OCT 10, with the time, 2:57 p.m. and Sharon's initials. She shoved the document back across the counter. Hearing set for next Tuesday. Judge Hargrove, Courtroom 4B, 9 a.m. sharp. Don't be late. Camille took the stamped copy and placed it carefully in her folio. Thank you. Sharon had already turned her back, returning to her desk. The younger clerk, Mitchell, was staring at his computer screen so intently it was obvious he was pretending not to have witnessed anything. Outside, the October afternoon sun felt too bright after the fluorescent gloom of the clerk's office. Camille walked to her car in the courthouse parking lot, got in, locked the doors, and sat for a full minute with her hands on the steering wheel. Then she opened her laptop and pulled up the Hughes case file. Yolanda Hughes, 62 years old, disabled since a car accident 5 years ago that crushed 3 vertebrae and left her dependent on a wheelchair and supplemental oxygen. Fixed income from disability payments. No family within 200 miles. She'd lived in her current apartment for 4 years, a ground floor unit with wheelchair accessibility and low rent that had stayed stable until 3 months ago. 3 months ago, the building was sold to Greenfield Properties, a real estate investment company based in Charlotte. New owners meant new management. New management meant rent increases. Mrs. Hughes's rent jumped from $950 to $1,300 overnight. She couldn't pay. Fell behind. 3 months of unpaid rent. 2 weeks ago, she found an eviction notice taped to her door. Not delivered by hand, not sent via certified mail, taped to her door with masking tape. The notice gave her 72 hours to vacate. North Carolina General Statute Section 4226 required 30 days written notice for month-to-month tenancies. Mrs. Hughes had a month-to-month lease. The notice she received gave her 3 days. Camille had tried negotiating with Greenfield Properties, called their property manager 6 times, left voicemails, sent emails. Finally got a call back from someone who identified himself only as Mark from Legal and informed her that Mrs. Hughes had waived her notice rights in her lease agreement. Camille found the lease, read it cover to cover, found the clause on page 14. Tenant waives all statutory notice requirements and agrees to vacate within 72 hours of written notice for non-payment. Standard boilerplate in Greenfield's leases, apparently. Also completely unenforceable under North Carolina law. Brown v. Keener, 175 North Carolina Appeals, 68. The State Court of Appeals had held that statutory tenant protections couldn't be waived by contract. Any clause purporting to waive those rights was void as against public policy. Camille had sent Mark from Legal a copy of Brown v. Keener with the relevant passages highlighted. Never got a response. Instead, she got a notice that the eviction was scheduled for Friday, October 13th at 10 a.m. A sheriff's deputy would arrive to remove Mrs. Hughes and her belongings from the premises. That was when Camille filed the emergency TRO, and Sharon Pruitt had just set the hearing for October 17th, 4 days after Mrs. Hughes would already be evicted. Camille closed the laptop and pulled out her phone, opened a new document and started typing. Motion for emergency advancement of hearing date. If this story is resonating with you, please hit that like button and subscribe. Your support helps us continue bringing these stories to light. The Duke Law Clinical Program office was mostly empty when Camille arrived at 4:30. Most students had finished their work for the day. A few remained in the library, heads bent over casebooks, highlighters moving across pages. Professor Washington's office was at the end of the hall. His door stood open. He sat at his desk with a stack of student briefs in front of him, red pen in hand, reading glasses perched on his nose. He looked up when she knocked on the doorframe. "How'd it go?" She handed him the stamped filing. He scanned the first page, noted the timestamp, flipped to the hearing date notation Sharon had scrawled at the bottom. They set it for after the eviction. "Yes." He set the document down and removed his glasses. "You expected this?" "I prepared for it. I drafted a motion for advancement this afternoon. I'll file it tomorrow morning." Professor Washington leaned back in his chair. He was 53, had been teaching at Duke for 18 years, ran the clinical program for 12. Before that, he'd spent 15 years as a public defender in Atlanta. He'd seen every trick prosecutors and judges could pull. Lost cases he should have won because the system protected itself. Won cases he should have lost because he'd documented every procedural violation meticulously. "Tell me what happened. Start at security." Camille walked him through it. Travis Mundy and the secondary screening. The 11 minutes and 40 seconds. The 3 white attorneys who'd passed through without issue. The wand pressed against her spine, his hand hovering near his weapon. Professor Washington's expression didn't change, but his jaw tightened. "And the clerk's office?" She described Sharon Pruitt's refusal. The claim about the missing signature page. The court reporter who'd slowed down. Mitchell, the younger clerk who'd witnessed everything but said nothing. The final stamp that Sharon had brought down like a gavel. When she finished, Professor Washington was quiet for a long moment. "Names?" "Travis Mundy, badge number 4792, Sharon Pruitt, chief clerk." He wrote them down in a small notebook he kept in his desk drawer. "You documenting?" "Everything. Times, dates, witnesses, exact words where I can remember them." "Photos? Video?" "Not yet. They wouldn't let me have my phone in secondary screening." "Next time, start recording before you go through security. Audio only if you have to. North Carolina's a one-party consent state. You can record any conversation you're part of without telling them." Camille nodded. She already knew that. Had looked up the statute last week when this started getting complicated. Professor Washington steepled his fingers, elbows on his desk. I need to ask you something, and I want you to be completely honest. Are you prepared for how hard they're going to push back? I'm prepared. Because courthouse staff doesn't like being challenged, especially by, he paused, especially by young black women who cite statutes at them? Yes. No hedging, no sugarcoating, just honesty. And it's going to get worse before it gets better. You file that advancement motion, they'll find another reason to delay. You push on the delay, they'll push back harder. You keep pushing, they'll start looking for ways to make your life difficult, make you want to give up. I won't give up. I believe you. But Camille, I also need you to think about Mrs. Hughes. If you make this a fight, they might take it out on her. Deny her benefits she's entitled to. Slow walk other cases she needs help with. Make her life harder because you made theirs harder. Camille had already thought about that. Stayed up until 2 a.m. last night thinking about it. Mrs. Hughes called me yesterday, told me she's lived in North Carolina her whole life, 62 years. And in all those years, every time she's needed help from the government, from the courts, from any official system, they've made it as difficult as possible. Made her wait, made her prove she deserved help, made her feel like she was asking for charity instead of claiming her rights. She met Professor Washington's eyes. She said if they're going to make it hard anyway, she'd rather fight and lose than roll over and accept it. So yes, I've thought about the risks, and I'm still going forward. Professor Washington smiled slightly, opened his desk drawer and pulled out a business card. Then you're going to need this. The card was simple. White stock, black text. Marcus Chen, Senior Staff Attorney, ACLU of North Carolina. A Raleigh phone number and email address below. Why would I need the ACLU for a landlord-tenant case? Because this stopped being just a landlord-tenant case the moment Sharon Pruitt refused your filing. The moment Travis Mundy held you in secondary screening for 12 minutes while white attorneys walked through. The moment you became a problem, they wanted to go away. He slid the card across the desk. You keep documenting. You keep fighting for Mrs. Hughes. But Camille, if things escalate, and I think they will, you call Marcus. Tell him I sent you. He'll know what to do. Camille pocketed the card. You think it'll escalate to federal civil rights litigation? I think you're about to find out what happens when a black woman with a Rhodes Scholarship and a photographic memory for case law challenges a system that's been running on autopilot for 20 years. Professor Washington's smile widened slightly. And honestly, I can't wait to watch. That night, Camille sat at her kitchen table with her laptop open and 3 legal pads spread out around her. 1 pad for the Hughes case, 1 for the advancement motion, 1 for something new, a timeline of courthouse incidents. She started with September 12th, her first visit to Durham County Justice Center. Travis Mundy had stopped her at security that day too. Secondary screening. 7 minutes. Claimed the metal detector had beeped, though she'd walked through it without incident after the screening. September 19th. Second visit. Travis again. Different excuse that time. Said her bag looked suspicious. Searched every compartment. 9 minutes. September 26th. Third visit. Travis again. No excuse offered. Just pointed at the secondary screening room. 8.5 minutes. October 3rd. Travis again. 11 minutes. October 10. Today. 11 minutes 40 seconds. Pattern established. Every single visit. Every single time, Travis Mundy was on duty. Every single time, secondary screening. Average duration, 9 minutes, 30 seconds. She opened a new document and formatted it as a spreadsheet. Columns, date, time, officer name, badge number, reason given, duration, white attorneys observed passing through without screening, filled in all 5 incidents. Under the last column, she noted September 12th, 4, September 19th, 2, September 26th, 3, October 3rd, 5, October 10th, 3. Total, 17 white attorneys who'd passed through security while she was detained, 0 secondary screenings. She saved the document, backed it up to 3 different cloud services, Then she pulled up North Carolina General Statute Section 143-4222.3. The statute Sharon had ignored when Camille read it aloud. She copied the full text into a new document. All persons entering courthouse facilities shall be subject to security screening without regard to race, color, or national origin. Security protocols shall be applied uniformly to all visitors. Any deviation from uniform application requires documented justification and supervisory approval. Documented justification. Supervisory approval. Travis had never documented anything, never called a supervisor until today when Sergeant Morrison told him to clear Camille through. She added that to her notes. Her phone buzzed. Text from Mrs. Hughes. "Did you file it?" Camille typed back, "Yes. Hearing is set for Tuesday, October 17th. 3 dots appeared immediately. That's after Friday, after they evict me. I know. I'm filing a motion tomorrow to move the hearing earlier, and if that doesn't work, I'm filing an immediate appeal." The 3 dots appeared again, disappeared, appeared. Finally, "Thank you for fighting." Camille set her phone down and looked at her timeline spreadsheet. 5 incidents, 17 white attorneys, 9.5 minutes average delay. Not enough data yet for a federal civil rights complaint, but getting there. She closed her laptop and went to bed, set her alarm for 5:30 a.m. The advancement motion needed to be perfect. Tuesday morning arrived cold and gray. Camille dressed carefully. Navy suit, white blouse, minimal jewelry. Professional. Serious. The kind of presentation that said, "I belong here," without having to speak the words aloud. She arrived at the courthouse at 8:20, 40 minutes before the hearing. Plenty of time. Travis Mundy stood at the security checkpoint. When he saw her approaching, something shifted in his expression. Not quite a smile, more like satisfaction. Secondary screening. No preamble this time. No pretense. Just the command. She followed him to the room. Same routine. Empty pockets. Remove shoes. Belt. Jacket. Watch. Earrings. But this time, before he picked up the wand, she pulled out her phone. "What are you doing?" "Taking notes." She opened the Notes app, typed October 17th, 8:21 a.m. Officer Mundy, badge 4792, secondary screening, 6th consecutive visit. Put that away. North Carolina is a one-party consent state. I'm allowed to document my own interactions with government officials. Travis's hand moved to his radio. "I said put it away." She lowered the phone but didn't turn it off, just held it at her side, screen facing her thigh. "Turn around. Arms out." The wand passed over her shoulders, down her spine. Slower this time. When it reached her lower back, Travis stopped, pressed the wand against her vertebrae hard enough that she had to step forward to keep her balance. "What's this?" "My spine." "Doesn't feel like a spine." Officer Mundy, unless you have medical training that qualifies you to diagnose skeletal abnormalities through a security wand, I suggest you move on. His jaw clenched. The wand stayed pressed against her back for 3 more seconds. 4. 5. Then he moved it down to her waist, her hips, taking his time with each pass. When he finally stepped back, she turned to face him. Her phone was still in her hand, screen visible. The Notes app showed her entry, time-stamped. "Am I clear?" "You think you're clever, don't you?" Travis set the wand down on the table, leaned against the wall, arms crossed. "Walking in here with your law school attitude, your filing, your cases. You think any of that matters? I think the Constitution matters, and North Carolina General Statute 143-42.3 matters. You know what I think?" He pushed off the wall, took a step closer. "I think you're making trouble where there doesn't need to be trouble. I think you're the kind of person who looks for problems, creates them if they're not there." Camille held his gaze. "I think I'm the kind of person who notices when the law isn't being applied equally, And I think you're the kind of person who doesn't like being noticed. Silence. Travis's hand moved to his belt. Not the radio this time. The other side, where his other equipment hung. His thumb hooked through a belt loop near it. You should be careful. Courthouse isn't always safe. Lots of people coming through, some of them not stable. Would be a shame if something happened. The threat hung in the air between them. Not quite explicit, plausibly deniable, but unmistakable. Camille's thumb moved on her phone screen. One tap. The voice recorder app activated. Is that a threat, Officer Mundy? His eyes flicked to her phone, registered what she'd done. His expression hardened. Just concerned for your safety. That's my job. Safety. Then I appreciate your concern. Am I free to go? He gestured toward the door. She gathered her belongings, but this time she kept her phone out, recorder still running. Walked through the metal detector. It didn't beep. In the hallway, she stopped the recording. Saved it with the file name. Mundy Threat 10-17. Uploaded it to cloud storage immediately. Then she climbed the stairs to the third floor. Courtroom 4B looked exactly like every other courtroom she'd seen. Wood paneling on the walls, rows of benches for the gallery, tables for counsel, one on each side. The judge's bench elevated above it all, American flag and North Carolina flag flanking it. The room was empty except for a bailiff arranging files at the clerk's table. Camille took a seat in the gallery and opened her binder. The advancement motion was 12 pages. 4 primary arguments. First, irreparable harm to Mrs. Hughes if the eviction proceeded before the hearing. Second, inadequate notice violated due process. Third, scheduling the hearing after the eviction rendered the court's review meaningless. Fourth, justice delayed is justice denied. She'd cited 8 cases, 3 North Carolina Court of Appeals decisions, 2 state Supreme Court cases, 3 federal cases on procedural due process, all directly on point. At 8:55, the door opened. A man walked in wearing a charcoal suit that probably cost more than Camille's monthly rent. Late 40s, graying at the temples in a way that made him look distinguished rather than old. Leather briefcase with brass fittings. Gold watch that caught the light. Elliot Chandler. She'd researched him thoroughly. Duke Law School, class of 2002. Graduated top 15%. Spent 5 years at a white shoe firm in Charlotte doing corporate defense. Made partner. Then surprised everyone by taking a 60% pay cut to join the Durham City Attorney's Office as a senior attorney. That was 11 years ago. In those 11 years, he'd never lost a case under 42 U.S.C. Section 1983. Never lost a civil rights complaint. Never had a judgment entered against the city in any case he'd personally handled. He was very, very good at what he did. And what he did was protect the city from people like Camille. Elliot sat at the respondent's table without acknowledging her, pulled files from his briefcase, arranged them in neat stacks, clicked his pen once, twice, then settled back in his chair to wait. At 9 a.m. exactly, the bailiff stood. All rise. The Honorable Judge Maxwell Hargrove presiding. A door behind the bench opened. Judge Hargrove entered in his black robe, reading glasses hanging from a chain around his neck. 64 years old. 23 years on the bench. Duke Law class of 1987. Same graduating class as Camille's father, 4th Circuit Judge Roland Booker. They'd been friends in law school, study partners, stayed in touch over the years, had dinner together when Judge Booker visited Duke for alumni events. But Camille didn't mention that. Wouldn't mention it, not unless it became necessary. Judge Hargrove sat, gestured for everyone else to do the same. First matter. Hughes versus Greenfield Properties, emergency TRO. Camille stood. Camille Booker for petitioner, Your Honor. Elliot rose smoothly. Elliot Chandler for respondent, Your Honor. Judge Hargrove looked at Camille over his reading glasses. Really looked at her. His eyes took in her age, her appearance, the Duke Clinical Program folder she carried. Something flickered across his expression. Not quite dismissal, but close. Ms. Booker, this is an emergency temporary restraining order. Tell me what makes it an emergency. Your Honor, my client is a 62-year-old disabled woman facing unlawful eviction this Friday without proper notice under North Carolina General Statute 42-26. The landlord provided only 72 hours written notice instead of the required 30 days. Mrs. Hughes uses a wheelchair and supplemental oxygen therapy for chronic respiratory issues. She has no family in the area and limited financial resources. If she's evicted from her current accessible housing, she'll have nowhere to go and no means to secure alternative housing on such short notice. This constitutes immediate and irreparable harm. Judge Hargrove's expression didn't change. How long have you been practicing law, Ms. Booker? The question landed like a brick. She kept her voice steady. I'm a third-year law student, Your Honor, certified to practice under North Carolina General Statute 84-4.1 through Duke Law School's clinical program. I'm supervised by Professor Jamal Washington, who has 18 years of... So you're not a lawyer. I'm certified to appear in court and represent clients under supervision, Your Honor. The statute... I know what the statute says, Ms. Booker. What I'm asking is how much practical courtroom experience you have. How many cases have you argued? How many TROs have you successfully obtained? She felt the trap closing. Answer honestly, and he'd use her inexperience against her. Hedge, and he'd call her evasive. This is my 14th appearance in court, Your Honor. I've argued 6 motions, 3 of which were granted. I've successfully obtained 2 preliminary injunctions in family court matters. But, Your Honor, my experience level doesn't change the fact that the law requires that counsel understand not just the statutes, but how to apply them, and that understanding comes from experience. Judge Hargrove picked up her motion, flipped through it. You've written quite an impressive brief here, lots of citations, very thorough, but it reads like a law school exam, Ms. Booker, academic, theoretical. Behind her, Camille heard someone enter the courtroom. Soft footsteps, the creak of a bench as they sat down. She didn't turn to look. Your Honor, with respect, North Carolina General Statute 42-26 is quite clear. It mandates 30 days written notice for... Judge Hargrove held up a hand. I can read, Ms. Booker. What I want to know is whether you understand the standard for emergency relief. Can you tell me what Rule 65 requires? Yes, Your Honor. Rule 65 requires the moving party to show 1. Immediate and irreparable harm. 2. Likelihood of success on the merits. 3. That the balance of hardships favors the moving party. And 4. That the public interest wouldn't be disturbed by granting the injunction. And you believe you've met that standard? Yes, Your Honor. Mrs. Hughes will lose her housing. That's irreparable harm. The landlord violated the notice statute. That establishes likelihood of success. Mrs. Hughes is disabled and has nowhere else to go while the landlord is a corporate entity that can easily wait 30 days. That's the balance of hardships. And the public interest favors ensuring that landlords comply with tenant protection statutes. Elliot Chandler stood. Your Honor, if I may. Judge Hargrove nodded. Go ahead, Mr. Chandler. Your Honor, respondent moves to dismiss. Petitioner failed to serve opposing counsel with the required notice under Rule 65b. Emergency TROs require notice to the adverse party except in very limited circumstances. Ms. Booker provided no such notice. Camille was already opening her binder. Tab 3, Certificate of Service, printed on Duke Law letterhead, notarized seal at the bottom. Your Honor, I have the certificate of service right here. The motion and all supporting documents were served on Mr. Chandler's office via email and certified mail on October 11th, 4 days ago. Elliot's tone stayed patient, almost kind, like he was explaining something to a child. Your Honor, email service is insufficient for emergency motions. This is basic civil procedure. Rule 65 requires actual notice, which means personal service or, at minimum, certified mail with return receipt. Ms. Booker may have sent an email, but that doesn't constitute proper notice under the rules. Camille pulled another document from her binder. Your Honor, may I approach? Judge Hargrove waved her forward. Elliot stayed at his table, confident, She handed the judge 2 documents. The first was her certificate of service, showing both email and certified mail. The second was an email from Elliot's office confirming receipt. Your Honor, this email is from Mr. Chandler's paralegal, Diane Foster, confirming receipt of all documents on October 11th at 2:37 p.m. Additionally, Rule 5 of the North Carolina Rules of Civil Procedure explicitly permits email service when parties have consented to electronic service. The city attorney's office consented to email service when they filed their initial response in this matter, which included their email address for service. Judge Hargrove read both documents. Elliot's expression tightened fractionally. "I'll allow it," Judge Hargrove said finally. "But Ms. Booker, in the future, when you're dealing with emergency matters, follow the most conservative interpretation of the rules. Better to overserve than underserve." "Understood, Your Honor." She returned to her table. Elliot was already standing again. "Your Honor, even if we accept that service was adequate, petitioner still lacks standing. Mrs. Hughes signed a lease agreement that expressly waives her right to challenge eviction procedures. That waiver is binding. She gave up her statutory protections voluntarily when she signed the lease. Camille didn't need her notes for this. She'd spent 6 hours researching this exact issue. Your Honor, waiver clauses for statutory tenant protections are void as against public policy under Brown v. Keener, 175 North Carolina App 68. The Court of Appeals held that tenants cannot waive statutory rights designed to protect them from exactly this kind of abuse. The legislature created these protections because of the inherent power imbalance between landlords and tenants. Allowing landlords to contract around those protections would render the entire statutory scheme meaningless. Elliot checked his legal pad. Found nothing. Camille saw the moment he realized she was right. The case was directly on point, and he had no good response. Judge Hargrove leaned back in his chair. "I'll take the matter under advisement." Hearing continued to Friday, October 20th, at 2 p.m. Your Honor, Camille stood. Mrs. Hughes's eviction is scheduled for this Friday, October 13th, at 10 a.m. Continuing the hearing until October 20th means she'll already be evicted 5 days before this court can rule. The TRO exists precisely to prevent irreparable harm, while the court considers the merits. If Mrs. Hughes is evicted before the hearing, the entire purpose of the TRO is defeated. Ms. Booker, this court has a full docket. I can't rearrange my entire calendar because you filed an emergency motion at the last minute. Your Honor, I filed within the time limits established by Rule 65. The emergency isn't of my making. It's created by the landlord's violation of the notice statute. And with respect, the statute requires this court to hold a hearing on a TRO within 14 days of filing. I'm asking for a hearing in 3 days, which is well within the statutory time frame. Judge Hargrove's expression hardened. And I'm telling you, Ms. Booker, that Friday, October 20th is when this hearing will occur. If Mrs. Hughes needs relief before then, she can pay her back rent and avoid eviction entirely. Your Honor, Mrs. Hughes cannot afford the back rent. That's why she's seeking protection under the notice statute. The statute exists specifically for people in her situation. Then she'll have to manage until October 20th. This court has other matters that take priority. Your Honor, I'd like to request findings of fact and conclusions of law for the appellate record. The courtroom went very quiet. Requesting findings meant she was planning to appeal. Everyone knew it. Judge Hargrove removed his reading glasses slowly. You may request whatever you like, Ms. Booker. Doesn't mean you'll get it. Your Honor, under Rule 52A, I'm entitled to findings of fact and conclusions of law when a court denies a motion for injunctive relief. Rule 52A says the court may provide findings, not must, and in this case, I'm declining to provide them. My ruling is sufficient. Camille stayed standing. Then, Your Honor, I'm filing notice of immediate appeal to the North Carolina Court of Appeals under Rule 2, and a motion for stay of eviction pending appeal. Elliot stood quickly. Your Honor, that's frivolous. You can't appeal a continuance. There's no final order to appeal. Mr. Chandler is incorrect, Your Honor. Under Rule 2, immediate appeal is permitted when a court denies emergency relief that, if not granted, would render any subsequent relief meaningless. If Mrs. Hughes is evicted before this court can hear the merits, any future ruling in her favor would be ineffective. That satisfies the standard for interlocutory appeal. Judge Hargrove stared at her. 5 seconds. 10. The bailiff shifted uncomfortably. And I suppose you have a motion for stay already prepared? Yes, Your Honor. May I approach? He gestured sharply. She brought him the motion, drafted last night, just in case. Judge Hargrove read it quickly, jaw working. Fine. Stay granted pending appeal. But, Ms. Booker, let me be very clear. If your appeal fails, and it will fail, you'll have wasted this court's time and your client's money. I suggest you think carefully about whether that's really in Mrs. Hughes's best interests. I have thought carefully, Your Honor, and I believe enforcing the law is always in my client's best interests. We'll see. Anything else? No, Your Honor. Then we're adjourned. The gavel came down. Hard. Camille packed her binder while Judge Hargrove left through the side door. Elliot gathered his files at his table. When the judge was gone and the bailiff had moved to the back of the room, Elliot walked over to her table. His voice was low enough that only she could hear. That was quite a performance. She didn't look up from organizing her papers. I wasn't performing. I was advocating for my client. Citing Brown versus Keener from memory, requesting findings for the record, filing for immediate appeal before the hearing even ends. Elliot's tone was almost admiring. You've clearly done your homework. Is there something you need, Mr. Chandler? Just wanted to offer some advice, off the record. Now she looked up. I'm not interested in your advice. You should be. He leaned against her table, casual. Because what you just did in there, challenging the judge's scheduling, accusing us of improper service, filing an immediate appeal, that's not how things work in Durham County. The rules are the rules. They work the same everywhere. Elliot smiled, not unkindly, almost pitying. That's exactly what someone who's been practicing for 5 minutes would say. But let me explain something to you. Judge Hargrove has been on the bench for 23 years. I've been practicing in this jurisdiction for 15. We have a relationship. We understand each other. We know how to make the system work efficiently. Efficiently for whom? For everyone, but especially for people who know how to work within the system instead of fighting against it. He straightened. You're a bright student, good instincts, solid research skills, but you're young, and you don't understand how quickly you can burn bridges in a small legal community like this. Are you threatening me, Mr. Chandler? I'm offering friendly advice. This case, Hughes versus Greenfield Properties, it's not the hill you want to die on. Your client is 3 months behind on rent. The landlord has a legitimate business interest in removing a non-paying tenant. You can dress it up with statutory arguments all you want, but at the end of the day, she owes money she can't pay. Fighting that isn't going to help her. It's just going to make enemies for you. Camille zipped her binder closed, stood to face him directly. Mr. Chandler, my client has rights under North Carolina law. Those rights don't disappear because she can't afford her rent. The statute requires 30 days' notice. The landlord provided 3. That's a violation. And I'm going to keep fighting until either the law is enforced or I exhaust every possible appeal. Elliot's smile faded. Then you're going to learn a hard lesson about what happens when idealism meets reality. He walked away. Camille watched him go, then pulled out her phone and added to her notes. Post-hearing conversation with Elliot Chandler. Suggested I'm making enemies. Implied system works better for those who don't challenge it. Warned me I'm burning bridges. Possible intimidation attempt. She saved the note and left the courtroom. We're at a crucial turning point in this story. If you want to see what happens next, please subscribe and hit that notification bell. The clerk's office was busy when Camille arrived 15 minutes later. Lunch hour rush. People filing documents, requesting copies, asking questions. The line snaked back from the counter almost to the door. Camille got in line. Waited. Watched the clerk's work. Sharon Pruitt was at the far end of the counter, processing a stack of files. When she glanced up and saw Camille in line, her expression soured. 20 minutes later, Camille reached the counter. Different clerk this time. Younger man, early 30s. Name tag read Mitchell Foster. I need to file a notice of appeal and motion for stay. Mitchell took the documents, scanned the first page. These are for Judge Hargrove's case this morning? Yes. He just ruled on this an hour ago. Yes, and I'm exercising my right to immediate appeal under Rule 2. Mitchell looked uncertain, glanced toward the back of the office where Sharon was working. I'll need to check if... Mitchell, Sharon appeared from the back office, saw Camille. Her jaw tightened. You again. I'm filing a notice of appeal and motion for stay. Sharon took the documents from Mitchell, flipped through them slowly, reading each page. 30 seconds, 45, a full minute. The people behind Camille in line shifted impatiently. Sharon set the documents on the counter. These need to be reviewed before acceptance. Rule 3 of the North Carolina Rules of Appellate Procedure states that the clerk shall accept all notices of appeal. There's no discretionary review process. The clerk's duty is ministerial. Are you telling me how to do my job again? I'm citing the rule. Sharon's voice rose slightly. Mitchell, get the supervisor. Mitchell hesitated, looked at Camille, looked at Sharon, then disappeared into the back office. 3 minutes passed. The line behind Camille grew longer. People muttered. Someone said, "Can we get another clerk over here?" Finally, a man in a tie emerged from the back. 50-some years old, graying hair, reading glasses on a chain. Name tag, Robert Hayes, clerk supervisor. What's the issue? Sharon gestured at the documents. This person is trying to file an appeal without proper authorization. Claims we have to accept it without review. Hayes picked up the notice of appeal, read the caption, glanced at the motion for stay, set them down. Looks standard. What's the problem? She's claiming Rule 3 requires immediate acceptance. It does. Hayes looked at Sharon. That's literally what Rule 3 says. The clerk shall accept notices of appeal, not may, shall. Sharon's face flushed. But we need to verify. There's nothing to verify. It's a notice of appeal. You stamp it, log it, and move on. Hayes turned to Camille. I apologize for the delay. These should have been accepted immediately. He took the documents, stamped them himself, the sound sharp in the busy office, and handed them back to Camille. Your copies. Original goes in the file. Court of Appeals will receive notice within 24 hours. Thank you. Sharon had turned away, her back rigid with anger. Outside, Camille called Professor Washington. I filed the appeal and got the stay. Tell me about the hearing. She walked him through it. Judge Hargrove's dismissive comments about her experience. Elliott's motion to dismiss over service. Her citation of Brown versus Keener. The continued hearing date after the eviction. Her request for findings that was denied. The immediate appeal that forced Hargrove to grant the stay. Professor Washington listened without interrupting. When she finished, he was quiet for a moment. You made an enemy today. I know. Judge Hargrove doesn't like being challenged in his courtroom, and he especially doesn't like being forced to grant stays because someone threatens to appeal. He forced my hand by scheduling the hearing after the eviction. I know, and you did exactly the right thing legally. But Camille, you need to understand, this is going to have consequences. Hargrove talks to other judges, Elliott talks to other city attorneys. Word gets around in the legal community that you're difficult, that you don't play by the unwritten rules. I'm okay with that. Are you? Because it means every future case you bring in Durham County is going to be an uphill battle. Every motion you file will be scrutinized twice as carefully. Every argument you make will be met with skepticism. Professor, I didn't go to law school to be liked. I went to enforce the law. If that makes me difficult, fine. She could hear the smile in his voice. Good answer. Just remember, document everything. This isn't over, it's just starting. He was right. That afternoon, Camille received an email from Alana Reeves, the junior associate who'd introduced herself in court. The subject line read, Case Law Help. Hi, Camille. I saw you're working on the Hughes appeal. I thought this might help. Attached is Mitchell versus Davidson County. It supports your argument about notice requirements. Good luck. Alana Camille opened the attachment. Read the case. Mitchell versus Davidson County, decided by the North Carolina Court of Appeals 12 years ago. The holding was clear. Landlords could not contract around statutory notice requirements, and any lease clause purporting to do so was void. Perfect. Exactly what she needed. Too perfect. She opened Shepard's citations and ran Mitchell versus Davidson County. Red flag. Overruled. State versus Henderson, 367 North Carolina 171, decided 3 years ago. The Supreme Court had explicitly overruled Mitchell, holding that under certain circumstances, notice waivers were enforceable. Camille read Henderson carefully. The case was distinguishable. It involved commercial leases, not residential. And the court had specifically noted that residential tenant protections remained intact. But if she'd cited Mitchell without checking Shepard's first, Elliott would have eviscerated her on appeal, made her look incompetent, destroyed her credibility. And Alana was a junior associate at the city attorney's office. She knew how to run Shepard's citations. She'd gone to law school, passed the bar. This wasn't an innocent mistake. This was sabotage. Camille screenshot the email, saved it to her growing courthouse access folder. Then she replied, Alana, thanks for the suggestion. I noticed Mitchell was overruled in State versus Henderson, 367 North Carolina 171. Were you aware? Just want to make sure we're both citing good law. Best. Camille. She sent it. Waited. No response. That night she created a new section in her case file. Professional misconduct. Under it, she filed the screenshot of Alana's email with a note. Attempted sabotage via bad law. Junior associate at opposing counsel's office sent overruled case with no warning about its status. Either gross incompetence or intentional misconduct. Given her position and legal training, intentional seems more likely. She saved the file and made 3 backup copies. The next 4 weeks passed in a blur of legal research and procedural battles. The Court of Appeals scheduled oral arguments for March 4th, 5 months away. In the meantime, the stay prevented Mrs. Hughes's eviction, but Greenfield Properties filed motion after motion trying to dissolve it. Motion to reconsider the stay. Denied. Motion to modify the stay to require Mrs. Hughes to pay ongoing rent. Granted partially, Mrs. Hughes had to pay current rent but not the back rent. Motion for sanctions against Camille for filing a frivolous appeal. Denied, but Judge Hargrove's written order included language about overzealous advocacy by inexperienced counsel. And through it all, Travis Mundy was at the security checkpoint every single time Camille visited the courthouse, October 24th. Secondary screening. 13 minutes. October 31st. Secondary screening. 15 minutes. Travis made her remove her shoes, belt, and jacket, then had her stand against the wall while he searched her bag compartment by compartment. November 7th. Secondary screening. 14 minutes. Travis questioned why she was visiting the courthouse. When she said she was filing a brief, he demanded to see it first. November 14th. Secondary screening. 16 minutes. Travis made her stand with her arms extended while he ran the wand over her body 3 times. November 21st. Secondary screening. 12 minutes. She documented every single one. Date, time, duration, reason given, comparison to other attorneys. By Thanksgiving, she had 11 incidents logged. Statistical pattern undeniable. And then came the parking garage. December 5th. Friday afternoon. Camille had just finished filing a response to Greenfield Properties' latest motion. It was getting dark early now, winter coming on. The parking garage was mostly empty at 4:30. She was halfway to her car when she heard footsteps behind her. Heavy. Quick. Hey! She turned. Travis Mundy. Out of uniform. Jeans, t-shirt, Durham Bulls cap. No badge, no name tag. nothing identifying him as law enforcement except the tactical watch she'd seen him wear at the security checkpoint. "Excuse me?" He stopped about 10 feet away. "You got a lot of nerve." Camille took 2 steps back, maintaining distance. Her hand moved to her bag, finding her phone. "I'm not interested in having this conversation." "Well, I'm interested in having it." Travis took a step closer. "You walk into that courthouse every week like you own the place, filing your motions, citing your cases, making trouble for people who are just trying to do their jobs." "I'm representing my client. If that's trouble, maybe you should ask yourself why." "Sharon's a good person. 20 years she's been working here. 20 years of doing everything right. And you come in with your law school attitude and make her look bad." "I didn't make anyone look bad. I cited the rules. If following the rules makes someone look bad, that's not my problem." Travis took another step. 8 feet now. "You think you're smart. You think that law degree is going to protect you." Camille pulled out her phone, opened the camera app, hit record. "State your name and badge number for the record." Travis froze. His eyes went to the phone, then to the security camera mounted on the garage ceiling 20 feet away. His jaw worked. "I'm off duty. I don't have to tell you anything." "Then this conversation is over." She kept the camera pointed at him, keeping him in frame. "If you continue approaching me, I'll file a harassment complaint with the Durham County Sheriff's Office." "Harassment." He laughed, but it didn't sound amused. "I'm trying to give you friendly advice. Watch yourself. Courthouse isn't always safe. Lots of people coming and going, some of them unstable. Would be a shame if something happened to you." "Are you threatening me, Officer Mundy?" "I'm expressing concern for your safety, that's all." But his eyes were hard. They stood there for 5 seconds. 10. Camille kept recording. Finally, Travis turned and walked back toward the elevator. She waited until the doors closed behind him, then stopped recording, saved the video with timestamp and location data, uploaded it to 3 different cloud services immediately. Then she got in her car, locked all the doors, and drove to Professor Washington's office. He watched the video twice. The second time, he paused it on Travis's face when he said, "Would be a shame if something happened to you." "That's a threat." "Plausibly deniable," Camille said. "He can claim he was expressing concern, maybe in isolation. But combined with the pattern of secondary screenings, the escalating delays, the confrontational behavior, this is harassment. You need to file a formal complaint." "With who? The sheriff's office?" "Travis works for them." "With everyone. Sheriff's office, yes. But also the ACLU and—" Professor Washington pulled out his phone. "I'm calling Marcus Chen right now." He dialed. Put it on speaker. 3 rings. "Marcus Chen." "Marcus, it's Jamal Washington at Duke. I'm here with a student who needs your help. You got a minute?" "For you? Always. What's going on?" Professor Washington gestured to Camille. She explained the whole thing, starting with the first secondary screening on September 12th, the pattern of delays, Sharon Pruitt's refusal to file her documents, Judge Hargrove's dismissiveness, Elliot's warning about making enemies, Alana's sabotage attempt with the overruled case, and finally, Travis's confrontation in the parking garage. Marcus was quiet for a moment after she finished. "How much of this have you documented?" "All of it. Dates, times, witnesses, exact quotes where I can remember them. Screenshots of emails. Video of the parking garage incident. Statistical analysis of the secondary screenings compared to other attorneys. Send it to me. Everything. I'll review it over the weekend and call you Monday." "Do you think it's enough for a civil rights complaint?" "I think it's enough for a pattern and practice investigation. Maybe more. But let me look at the evidence first. Jamal, you still there?" "Yeah." "She safe?" Professor Washington looked at Camille. "Are you?" "I'm careful. I don't go to the courthouse alone anymore. I tell people where I'm going. I document everything." "That's not what I asked." Camille thought about Travis's hand near his holster. His threat in the parking garage, the way his eyes had gone flat and cold. I don't know. Then we act fast, Marcus said. Send me everything tonight. I'll have a preliminary review done by Monday morning. And Camille, until we figure out next steps, you don't go to that courthouse without someone with you. Understood? Understood. They hung up. Professor Washington walked her to her car, waited until she was inside with the doors locked before heading to his own vehicle. That night, Camille compiled everything, created a master document with timeline, incident reports, supporting evidence, 37 pages, 13 separate incidents. 42 white attorneys observed passing through security without secondary screening while she was detained. Average delay, 13 minutes, 22 seconds. Pattern clear. Statistically significant. Legally actionable. She attached the video of Travis's threat, screenshots of Alana's sabotage attempt, copies of her motions with Sharon's handwritten notes scheduling hearings after evictions, transcript excerpts from Judge Hargrove's comments about her inexperience. She sent it all to Marcus Chen at 11:43 p.m. He responded at 11:45. Got it, go get some sleep, we'll talk Monday. But she couldn't sleep. Instead, she opened a new document and started drafting. Complaint for injunctive relief and damages. Camille Booker, plaintiff, vs. Durham County. Travis Mundy, Sharon Pruitt, Elliot Chandler, John Doe. Security officers 1 to 5 and Jane Doe clerks 1 to 3. Defendants' violations. 42. USC. Sierra 1983. Denial of access to courts. 18 USC. Sierra 242. Deprivation of rights under color of law. North Carolina General Statute. ER 143. 422.3. Discriminatory enforcement. Brady violation. Withholding exculpatory evidence. She wrote until 3 a.m. When she finally stopped, she had 49 pages. Evidence. Legal analysis. Prayer for relief that included damages, injunctive relief, policy reforms, and attorney's fees. She saved it, but didn't file it. Not yet. Wait for Marcus's review. Wait for the right moment. But the complaint was ready, loaded, just waiting for the trigger. Monday morning, Marcus called at 9 a.m. I reviewed everything you sent. This is solid, really solid. Pattern of harassment, discriminatory enforcement, possible judicial bias. We could file tomorrow if you wanted to. But I think we should wait. Let them escalate a bit more. Right now, they can claim isolated incidents, misunderstandings, judgment calls. If we wait, they'll keep pushing. And every time they push, you document it. Build the pattern until it's absolutely undeniable. How long? Through your oral arguments in March. That's 4 months. Keep documenting every courthouse visit, every interaction, every delay. By the time we file, we'll have 6 months of evidence instead of 2. Makes the pattern impossible to dismiss. Camille thought about Travis's threat, Sharon's hostility, Elliot's warnings. 4 more months of that. And if something happens to me before March? Then we file immediately and include assault charges. But Camille, I don't think they're that stupid. They're bullies, but they're not criminals. They're trying to make you quit. Make you give up. Go away. If you don't, if you keep showing up, keep documenting, keep fighting, they'll eventually make a mistake big enough that we can bury them with it. Okay, I'll wait until March. In the meantime, send me weekly updates. Every courthouse visit, every incident, everything. And Camille, be careful. These people have power and they're used to using it. She promised to be careful. Hung up. Looked at her calendar. Today was December 11th. Oral arguments were March 4th. 84 days. She could survive 84 days. She had to. December turned to January, then February. The oral arguments loomed closer, and with each passing week, the pattern of harassment grew more documented, more undeniable, more purposeful. December 18th, Travis at security. Secondary screening. 17 minutes. He made her stand with her arms extended overhead while he ran the wand up and down her sides, the device lingering at her ribs, her waist, her hips. When she asked if she could lower her arms, he said, "When I'm done." A white male attorney walked through the main checkpoint during minute 14. Waved through without question. Camille documented it. Date, time, witness description, added it to the spreadsheet. Incident 14, January 9th, secondary screening, 19 minutes. Travis questioned why she needed to visit the courthouse so frequently. She explained she was working on an appellate brief. He demanded to see her bar card. She showed him her student certification. He said it looked fake, called his supervisor. Sergeant Morrison arrived, glanced at the certification, told Travis it was legitimate, and walked away shaking her head. 19 minutes total. 3 attorneys passed through the main checkpoint. All white, all men. 0 secondary screenings. Incident 15, January 16th. Sharon Pruitt lost another filing. This time it was Camille's response to Greenfield Properties' motion for summary judgment. The motion was 43 pages with 68 exhibits. Camille had the certified mail receipt showing delivery to the clerk's office at 9:47 a.m. Sharon claimed the package never arrived. Camille produced the tracking receipt, signed by S. Pruitt at 10:03 a.m. Sharon's face went pale, then red. "That's not my signature." "It's printed here, S. Pruitt, and this is your office." "Someone else must have signed for it." "Who?" Sharon didn't answer, just stamped the duplicate copy Camille had brought. She'd learned to always bring backups, with enough force to leave an impression on the counter. Camille photographed the tracking receipt and Sharon's signature side by side, added it to her evidence file. January 23rd. Camille arrived at the courthouse to file a notice of compliance with a court order. Travis wasn't at security. Different guard. Older man, gray hair, wedding ring. He looked at Camille, looked at the metal detector, and waved her through. "Have a good day, ma'am." No secondary screening, no demands, no delays. She was through security in 45 seconds. The relief was overwhelming. And also damning, because it proved that the harassment wasn't about security protocols or reasonable precautions. It was about Travis Mundy specifically targeting her. She documented that too. Control incident. Different guard, no delay, professional treatment. January 30th. Travis was back. Secondary screening. 21 minutes. He made her remove her shoes, belt, jacket, watch, earrings, and empty every pocket. Laid everything on the table. Ran the wand over each item individually. Then made her stand against the wall while he searched her bag so thoroughly he pulled the lining partially loose. "You're going to damage my bag." Just being thorough. 21 minutes. 4 attorneys passed through. 2 white women, 2 white men. 0 secondary screenings. Incident 17. But it wasn't just Travis and Sharon anymore. The harassment had evolved, become more sophisticated. February 6th. Camille received an email from Elliot Chandler's office. Not from Elliot himself, from Alana Reeves. Subject: Discovery responses. "Hi Camille, attached are our responses to your discovery requests in Hughes Vive. Greenfield Properties. Let me know if you have questions. Alana." Camille opened the attachment. 47 pages of responses. Most of them were boilerplate objections. Overly broad. Unduly burdensome. Not reasonably calculated to lead to discoverable evidence. But one response stood out. Interrogatory 12 had asked Greenfield Properties to identify all communications with the city attorney's office regarding Mrs. Hughes's case. Response: after diligent search, no responsive documents located. That was a lie. Camille had seen the email from Sharon to Elliot about losing her service copy. She had the screenshot. That email proved coordination between the clerk's office and the city attorney. And since Greenfield Properties was represented by the city attorney's office, that coordination was discoverable. She drafted a motion to compel, attached the email as evidence, filed it February 9th. 3 days later, she got a call from Elliot Chandler himself. "Ms. Booker, we need to talk about your motion to compel." "I'm listening." "That email you attached, the one from Sharon Pruitt, that's attorney work product. You obtained it improperly during discovery in a separate matter. Using it in this case violates professional ethics rules." The email wasn't marked as privileged. It was produced in response to a proper discovery request. "And it's directly relevant to whether your client coordinated with court staff to obstruct my filings." "You're accusing court staff of obstruction?" "I'm presenting evidence of coordination that resulted in my filings being lost and my hearings being scheduled after evictions. The court can draw its own conclusions." Elliot's voice hardened. "Ms. Booker, you're playing a dangerous game. You're making serious accusations against people who have served this community for decades. You're damaging your own reputation. And for what? A tenant who owes 3 months' rent?" "For the principle that the law applies equally regardless of who you are or who you know. Principles don't pay the bills, and they don't get you hired after graduation. You might want to think about your future before you burn every bridge in Durham County." "Is that another threat, Mr. Chandler?" "It's a reality check. You have talent, real talent. I've been impressed with your legal analysis. But talent doesn't matter if no one will hire you because you're known as difficult." "Then I'll go somewhere that values lawyers who actually enforce the law." Elliot was quiet for a moment. "I hope you know what you're doing." He hung up. Camille added notes to her file. February 12th, phone call with Elliot Chandler. Claimed email evidence was improperly obtained. Warned about reputation damage. Suggested my talent being wasted by fighting. Clear attempt to intimidate into dropping motion to compel. She kept the motion pending. February 20th, 2 weeks before oral arguments. Camille filed her final brief with the Court of Appeals. 112 pages, 73 case citations, every argument researched to exhaustion, every possible counter-argument anticipated and rebutted. Professor Washington read it twice. "This is appellate-level work, better than most practitioners I know." "Will it be enough?" "Legally? Yes. But Camille, you need to prepare yourself for the possibility that you win the legal argument and still lose the case." "What do you mean?" "I mean, appellate courts have a lot of discretion. They can find procedural reasons to avoid the merits. They can affirm on alternative grounds. They can rule that even if the trial court was wrong, the error was harmless." He paused. "Especially when ruling for you means reversing a judge who's been on the bench for 20 years and calling out a city attorney who's never lost a civil rights case. So what am I supposed to do? Just accept that the system protects itself?" "No, you fight anyway, because even if you lose this case, you're building a record. Every brief you file, every argument you make, every piece of evidence you document, it's all part of a larger pattern, and eventually, that pattern becomes impossible to ignore. Even if it takes years?" "Even if it takes years." February 27th, final pre-argument preparation. Camille did a moot court session with 3 Duke law professors playing the appellate panel. They grilled her for 90 minutes, every weak point in her argument, every case that cut against her, every fact that could be interpreted favorably to Greenfield Properties. By the end, she was exhausted, but ready. That night, she reviewed her evidence file one last time, sent the weekly update to Marcus Chen. 23 incidents now. Statistical analysis showed she was detained at security 92% of the time Travis was on duty. Average delay, 15 minutes, 38 seconds, compared to 0% for white attorneys during the same time periods. Pattern established. Undeniable. Marcus's response came at midnight. "You're building a bulletproof case. Stay strong. 7 more days." March 3rd, eve of oral arguments. Camille drove to Raleigh and checked into the same budget hotel she'd used before. Reviewed her notes until 2 a.m., slept 4 hours. Woke at 6. Dressed carefully. Navy suit, white blouse, pearl earrings, professional, serious, ready. Arrived at the North Carolina Court of Appeals building at 8:30. Oral arguments were scheduled for 10 a.m. The building was impressive. Granite facade, marble floors, high ceilings, portraits of former judges lining the walls. This was where real law happened, where precedent was made, where justice, when it worked, actually functioned. Elliot Chandler arrived at 9:15. He had 2 associates with him this time. Alana Reeves and another junior attorney Camille didn't recognize. They set up at one of the counsel tables in the courtroom, spreading files and documents with practiced efficiency. At 9:45, the courtroom started filling. Other attorneys waiting for their cases. Law students observing. A court reporter setting up her stenography machine. And in the back row, Professor Washington. He'd driven up to watch, gave Camille a small nod when she turned around. At 10 a.m., the bailiff stood. "All rise. The North Carolina Court of Appeals is now in session. The Honorable Judge Sarah Lanning presiding, joined by Judge Marcus Simmons and Judge Patricia Kearney." 3 judges entered and took their seats at the elevated bench. Judge Lanning in the center, 50s, sharp eyes behind wire-rimmed glasses. Judge Simmons on the left, 60s, African-American, former civil rights attorney. Judge Kearney on the right, 40s, youngest person ever appointed to the Court of Appeals. Judge Lanning looked at the case file in front of her. First case, Hughes versus Greenfield Properties. Appeal from Durham County Superior Court. Mr. Chandler, you're the appellee. You may proceed. Elliot stood, smooth, confident, 15 years of experience on display. May it please the court, this case is about a tenant who stopped paying rent and now seeks to avoid the consequences through creative statutory interpretation. The trial court properly denied emergency relief because the petitioner failed to meet the high standard required for TROs. That ruling was within the court's discretion and should be affirmed. Judge Simmons leaned forward. Mr. Chandler, didn't the landlord provide only 3 days' notice when the statute requires 30? The landlord provided the notice required under the lease agreement, Your Honor. The tenant voluntarily waived her statutory rights when she signed the lease. Can statutory tenant protections be waived? Judge Kearney asked. In certain circumstances, yes. When a tenant is sophisticated enough to understand what she's agreeing to, and when the waiver is clearly stated in the contract, courts enforce those agreements. Judge Lanning flipped through the brief. Isn't there a case, Brown v. Keener, that holds otherwise? Brown is distinguishable, Your Honor. That case involved retaliatory eviction. This case involves non-payment of rent. Different facts, different outcome. Camille listened carefully. Elliot was good. Very good. He'd anticipated the court's questions and had answers ready. But he was making one critical mistake. He was misrepresenting Brown versus Keener. After 15 minutes, Elliot sat down. Judge Lanning turned to Camille. Ms. Booker, your turn. She stood, placed her notes on the podium but didn't look at them. She'd memorized every argument. May it please the court. This case is about whether landlords can contract around tenant protection statutes designed to prevent exactly this kind of abuse. The answer, under North Carolina law, is no. Brown v. Keener establishes that statutory tenant protections cannot be waived. The trial court erred in denying relief, and this court should reverse. Judge Lanning didn't wait. Ms. Booker, your brief cites Booker v. North Carolina extensively. Are you aware that case addresses qualified immunity for state actors, not private landlord-tenant disputes? The question hung in the air. This was it, the moment she'd been preparing for. I'm aware, Your Honor. Booker held that qualified immunity applies only when the constitutional right violated was not clearly established at the time of the violation. Here, the right to notice under the Fair Housing Act and North Carolina General Statute 42-26 was clearly established in 1988. The underlying principle that clearly established rights cannot be violated under the guise of immunity or waiver applies here. Judge Lanning studied her. You seem very familiar with Booker. Have you read it carefully? Many times, Your Honor. The concurrence in particular? Camille's heart rate picked up slightly. Why was the judge asking about the concurrence specifically? Yes, Your Honor. Judge Roland Booker's concurrence addressed the scope of qualified immunity in cases involving procedural violations. He argued for a narrower interpretation than the majority. And how does that apply here? Judge Booker's concurrence emphasizes that procedural protections exist to check government power. The same principle applies to statutory tenant protections. They exist to check landlord power. Allowing those protections to be waived undermines their entire purpose. Judge Simmons spoke up. Ms. Booker, even if you're right about the notice violation, your client still owes 3 months' rent. How does correcting the procedural error help her? It gives her time, Your Honor, 30 days' notice instead of 3. Time to find alternative housing. Time to access social services. Time to avoid becoming homeless. The statute recognizes that disabled tenants, especially those with limited resources, need that time to avoid irreparable harm. And if we reverse and remand, what happens? The trial court holds the hearing it should have held before the eviction, weighs the evidence, makes findings of fact, follows the law. That's all we're asking for, a fair hearing under the correct legal standard. Judge Kearney leaned back. Ms. Booker, the trial judge has been on the bench for over 20 years. He denied your motion. What makes you think he got it wrong? The question was sharp, challenging her directly. Your Honor, respectfully, experience doesn't equal infallibility. The trial court denied relief without findings of fact, without analyzing the statutory requirements, without applying Brown versus Keener, which is directly on point and binding precedent. The law is the law, regardless of who sits on the bench. Judge Lanning's eyebrow raised slightly. Not many young attorneys spoke that directly about trial judges. The judges asked 8 more questions. Camille answered each one, cited cases from memory, distinguished adverse precedent, built her argument brick by brick. When her time expired, she sat down. Elliot stood for rebuttal. Your Honor, Ms. Booker has done an admirable job with this appeal. Her brief is thorough. Her argument is well researched, but she's asking this court to second-guess the trial judge's discretionary decision based on a misreading of Brown versus Keener and an inapplicable case about qualified immunity. He paused for effect. And regarding Booker versus North Carolina, if you read Judge Booker's concurrence carefully, which I recommend the court do, you'll find he actually supports the proposition that immunity applies broadly to protect good faith actors from technical violations. That principle extends to landlords acting in good faith under lease agreements. Camille's pen stopped mid-note. Elliot had just cited her father's concurrence, and he'd gotten it completely wrong. Judge Booker's concurrence argued for narrower immunity, not broader. Elliot had either misread it or was deliberately misrepresenting it to the court. But she couldn't speak. Her time was over. The judges thanked both sides. We'll take the matter under advisement and issue a written opinion within 90 days. Court is adjourned. Outside the courtroom, Professor Washington caught up with her. You did great in there. Elliot misrepresented my father's concurrence. I caught that. You think he knows? Knows what? That Judge Booker is your father. Camille shook her head. No, he would have disclosed it if he knew. Probably would have moved for recusal. So he just cited it without reading it carefully. Apparently. They walked toward the exit. Elliot was ahead of them, talking to his associates in the hallway. As Camille passed, he turned. Nice argument, Ms. Booker. You've definitely improved since your first appearance. She stopped. Thank you. That point about Booker was clever, using the concurrence to support your position, but you should read the case more carefully. Judge Booker's actual holding supports immunity, not restriction. I've read it carefully, Mr. Chandler. Well, when you've practiced appellate law as long as I have, you learn to distinguish between what a case says and what advocates want it to say. Camille looked at him. This moment had been inevitable. From the first secondary screening, the first refused filing, the first dismissive comment, everything had been building to this. Mr. Chandler, when I see my father next, I'll let him know you think his concurrence was misread. Elliot's expression froze. Your father? Judge Roland Booker, Fourth Circuit Court of Appeals, author of Booker versus North Carolina, the case you've been citing to support your position for the past 6 months. The color drained from Elliot's face. Behind him, Alana Reeves stopped mid-sentence, her mouth falling open. Judge Booker is... My father, yes. Camille pulled a document from her bag. Her bar application, which she'd brought specifically for this moment. And since we're clarifying things, this is my application to sit for the North Carolina bar exam next month. One of my references is Justice Sonia Sotomayor. I clerked for her last summer at the Supreme Court. She handed him the application. He took it mechanically, eyes scanning the page. This is the moment everything changes. Make sure you're subscribed to see how the system responds when it realizes who Camille really is. Elliot's hands trembled slightly as he held the document. Why didn't you disclose this? Disclose what? That my father wrote a case you chose to cite? That's your burden, Mr. Chandler, not mine. You're the one arguing before a court. You're the one who has to check for conflicts. But you let us think you were just a student. I am just a student, a third-year law student representing a client through a clinical program. My father's position doesn't change that. The law doesn't change based on whose daughter I am. Professor Washington stepped closer, his presence a quiet reinforcement. Elliot's jaw worked. Judge Hargrove will need to know about this. Judge Hargrove already knows, or he should if he'd done basic conflict checking. My father and Judge Hargrove were classmates at Duke Law, class of 1987. They've stayed in touch over the years. Elliot's face went from pale to red. That's a conflict of interest. Judge Hargrove should have recused himself. Should he? My father isn't a party to this case. He has no financial interest in the outcome. Under what standard would recusal be required? The appearance of impropriety. Your father is a federal appellate judge. You're appearing before his law school friend. That creates an appearance of bias. Camille smiled slightly. Funny, you didn't seem concerned about appearances when you were arguing that Judge Hargrove's discretionary decisions should be given deference, when you were asking the appellate court to affirm without questioning his judgment. But now that you know my connection, suddenly there's an appearance problem? Elliot opened his mouth, closed it, opened it again. Nothing came out. If you want to file a motion for recusal, Mr. Chandler, that's your right. But you'll have to explain to Judge Hargrove why you're suddenly concerned about conflicts after 6 months of litigation. And you'll have to explain to the Court of Appeals why you cited a case without knowing who wrote it. She took the bar application back from his hands. Now, if you'll excuse me, I have a 3-hour drive back to Durham. She walked away. Professor Washington followed. Behind them, Elliot stood frozen in the hallway, Alana staring at him with wide eyes. In the car, Professor Washington waited until they were on I-40 before speaking. That was nuclear. He misrepresented my father's opinion to an appellate court. He deserved to know who wrote it. He's going to file for recusal. I know. Which means the case goes back to Durham County for reassignment. I know that too. And you're okay with that? Camille thought about it. Mrs. Hughes's case would be delayed by the recusal. Maybe months, but the alternative was letting Elliot Chandler misrepresent case law without consequences, letting Judge Hargrove preside over a case where he had an undisclosed relationship with her father. I'm okay with it, because now they can't claim I ambushed them. Elliot raised the conflict himself, in front of witnesses, in the courthouse hallway. And you just happened to have your bar application with you? I brought it for exactly this reason. I knew he'd cite Booker eventually, and I knew he'd get it wrong because he's been getting it wrong all along. I just needed him to do it in a place where it mattered. Professor Washington smiled. You've been planning this. I've been preparing for every possibility. They drove in silence for a while. Then Professor Washington asked the question that mattered. What happens now? Now I file the civil rights complaint, because if Elliot files for recusal, he admits that Judge Hargrove had a conflict all along, admits that every ruling Hargrove made could have been influenced by his relationship with my father. Admits that the entire case was tainted from the start. And that supports your argument that you were treated differently because of who you are. Exactly. They dismissed me as just another student with no connections, treated me accordingly, delayed my hearings, lost my filings, harassed me at security, made my client's case harder at every turn. But I do have connections, and they should have checked before assuming I didn't. Professor Washington was quiet for a moment. You're going to bury them. I'm going to hold them accountable. There's a difference. Back at Duke, Camille went straight to her apartment, opened her laptop, pulled up the civil rights complaint she'd been drafting for months. 63 pages. Every incident documented, every statute violated, every remedy requested. She updated it with the new information, added a section about Elliott's misrepresentation of Booker versus North Carolina, added exhibits, the video from oral arguments showing his statement about Judge Booker's concurrence, followed by law review articles analyzing the actual holding. Added another section about judicial bias, Judge Hargrove's friendship with Judge Booker, undisclosed for 6 months, his dismissive comments about her experience, his denial of findings of fact, his scheduling of hearings after evictions. By midnight, the complaint was 87 pages. She saved it, backed it up to 4 different cloud services. Then she called Marcus Chen even though it was late. Marcus, it's Camille. Elliott knows. Knows what? About my father. I told him today after oral arguments. Marcus was silent for a beat. Walk me through what happened. She explained, the misrepresentation of the concurrence, Elliott's condescension, the reveal, his immediate panic about recusal. When she finished, Marcus laughed. Actually laughed. You played him perfectly. I didn't play anyone. I just corrected his misrepresentation of case law. Right. And you just happened to have your bar application showing Judge Booker as your father ready to hand him. I believe in being prepared. Camille, this is brilliant. If he files for recusal, he admits the conflict. If he doesn't file, he's stuck with a record where he misrepresented a federal judge's opinion, a federal judge who happens to be opposing counsel's father. Either way, he loses. So we file the complaint now? No, we wait for his next move. If he files for recusal, we include that in the complaint as evidence of the systemic bias you faced. If he doesn't file, we file anyway and note that he failed to move for recusal even after learning of the conflict. Either way, we win. How long do we wait? 72 hours. He'll file within 3 days or not at all. Marcus was right. 48 hours later, Camille received notice of a new motion filed in Durham County Superior Court. Motion for recusal of Judge Maxwell Hargrove. Respondent moves for recusal of Judge Maxwell Hargrove under 28 U.S.C. Sefer 455, B5. If you, upon information recently disclosed, opposing counsel Camille Booker is the daughter of Fourth Circuit Judge Roland Booker. Judge Hargrove and Judge Booker attended Duke Law School together, class of 1987, and maintain a social and professional relationship. This creates an appearance of bias requiring recusal under the Code of Judicial Conduct. Additionally, the undersigned inadvertently cited Booker v. North Carolina during appellate oral arguments without knowledge of opposing counsel's relationship to the author. This creates a further appearance of impropriety that warrants recusal and reassignment to avoid any perception of unfairness. Camille read it 3 times. Elliott had done exactly what she'd expected, admitted the conflict, admitted his mistake, gave her everything she needed. She called Marcus. He filed. I know. I got copied on it. You ready to file the big one? More than ready. Then let's do this. I'll review your complaint tonight. We file tomorrow morning. That night, Camille made the final edits, added Elliott's recusal motion as Exhibit A, added the transcript from oral arguments as Exhibit B, added Judge Hargrove's order denying her request for findings of fact as Exhibit C, added Travis Mundy's personnel file, obtained through FOIA, as Exhibit D, showing 6 prior complaints for excessive force and racial profiling, added Sharon Pruitt's emails coordinating with Elliott as Exhibit E, Added her statistical analysis of security screenings as Exhibit F, 23 incidents, 92% detention rate when Travis was on duty, 0% for white attorneys during same periods. Added the video of Travis's parking garage threat as Exhibit G. Added everything, every incident, every violation, every piece of evidence she'd been collecting for 6 months. The final complaint was 104 pages. Caption: Camille Booker, v. Durham County, Travis Mundy, Sharon Pruitt, Elliot Chandler, and John Doe's, 110. Causes of action: 42 U.S.C., Section 1983, denial of access to courts. 18 U.S.C., FARI 242, deprivation of rights under color of law. North Carolina General Statute, SAR 143, 422.3, discriminatory enforcement. Brady violation, withholding exculpatory evidence. Judicial misconduct, failure to recuse despite conflict. Prayer for relief. Compensatory damages, $150,000. Punitive damages, $500,000. Injunctive relief requiring policy reforms at Durham County Justice Center. Appointment of independent monitor for courthouse security practices. Mandatory anti-bias training for all courthouse staff. Attorney's fees and costs. Any other relief the court deems just and proper. She read it one final time. Then she sent it to Marcus. His response came at 2 a.m. This is the most thorough civil rights complaint I've seen in 15 years of practice. File it. March 7th, 3 days after oral arguments. Camille walked into the Durham County Justice Center one final time. Travis Mundy was at security. He saw her coming and his expression hardened into something familiar. Anticipatory, ready to make her day difficult again. Secondary. She held up a document. Officer Mundy, this is a copy of a federal civil rights complaint I'm filing this morning in the U.S. District Court for the Middle District of North Carolina. You're named as a defendant. You'll be served formally within 72 hours. I'm providing you this courtesy copy now. Travis's face went blank. He took the document automatically, started reading. This also names the Durham County Sheriff's Office, the Clerk of Courts, and several John Doe defendants. I'm identifying you specifically because of your pattern of discriminatory security screenings documented over the past 6 months. Travis looked up. What? 23 incidents. Statistical analysis attached as Exhibit F. Video evidence of your parking garage threat attached as Exhibit G. I suggest you contact your union representative and retain legal counsel. She walked past him to the metal detector. It beeped. She stopped, waiting. Travis just stared at the complaint in his hands. Didn't move. Officer Mundy, the detector. He looked up like he'd forgotten she was there, waved her through without a word. She rode the elevator to the second floor. Sharon Pruitt was at the clerk's counter. Camille approached and placed an identical copy of the complaint on the counter. Ms. Pruitt, this is a courtesy copy of a federal civil rights complaint I'm filing this morning. You're named as a defendant for coordinating with opposing counsel to obstruct my filings and deny my client access to the courts. You'll be served formally within 72 hours. Sharon's hands trembled as she picked up the document, started reading. Her face went white. This is... You can't... I can, and I have. The complaint includes emails you sent to Elliot Chandler discussing ways to delay my filings. Those emails were produced during discovery. They're now part of the federal record. Sharon's mouth opened, closed, opened again. No words came out. I need to file this in the federal courthouse, which is across town, but I wanted you to know first. Professional courtesy. Camille turned and walked away. Behind her, she heard Sharon's voice, high and panicked. Get me Robert! Get me Robert now! Outside, Professor Washington was waiting in his car. He'd driven with her for safety. How'd it go? Travis looked like he'd been hit by a truck. Sharon looked like she might faint. Good. Let's go file this thing. The federal courthouse was different from Durham County. Bigger, newer, more professional. The security guards were U.S. Marshals, not local officers. They were polite, efficient, thorough. Camille passed through security in 90 seconds. The clerk's office for the U.S. District Court was on the second floor. She walked up to the counter and presented the original complaint plus 4 copies, filing a new civil rights action. The clerk, a middle-aged woman with reading glasses on a chain, took the documents and scanned the caption. Her eyebrows rose. "This is against Durham County?" "Yes, ma'am." "And several individual defendants?" "Yes, ma'am." The clerk read the first few pages, stamped each copy with the filing date and time, assigned a case number, handed Camille her copies. "You'll need to serve all defendants within 90 days. The court will assign a judge within 48 hours. Good luck." "Thank you." Outside, Camille stood on the courthouse steps and called Marcus Chen. "It's filed." "Case number?" She read it off. 125 CV 00142. "I'm pulling it up now. Looking at the docket. Okay, I see it. Camille Booker versus Durham County, et al. Filed March 7th, 2025 at 10:47 a.m. He paused. "This is really happening. This is really happening. You ready for what comes next?" "What comes next?" "They're going to fight back. Hard. Motion to dismiss. Discovery battles. Depositions where they try to break you down. Settlement offers designed to make you go away quietly. This could take years." "I know." "And you're still in?" Camille looked at the federal courthouse behind her. Clean lines, American flag flying. The words "Equal Justice Under Law" carved in stone above the entrance. "I'm still in." The response was faster than she expected. 2 days later, the Durham County Attorney's Office issued a press release. Durham County responds to allegations. Durham County has been made aware of allegations filed by a law student regarding courthouse security procedures and administrative processes. The county takes all such allegations seriously and has initiated an internal review. While we cannot comment on pending litigation, we remain committed to ensuring fair and equal treatment for all courthouse visitors. The individuals named in the complaint are dedicated public servants who have served Durham County with distinction for many years. We are confident that a full review of the facts will demonstrate that all actions taken were appropriate and in compliance with established procedures. Translation: they were circling the wagons. March 12th, Camille received a call from an unknown Raleigh number. "Ms. Booker, this is Jennifer Lowe, Deputy County Attorney for Durham. I'm calling about the complaint you filed." "I'm listening." "The county would like to explore the possibility of resolving this matter without protracted litigation. Would you be amenable to a settlement discussion?" "That depends on what you're offering." "We'd need to meet in person to discuss specifics. Could you come to our office next week?" "I can meet, but I'm bringing my attorney." "Of course. We'd expect no less. How's Tuesday, March 18th at 2 p.m.? Camille checked her calendar. "That works." She called Marcus immediately after hanging up. "They want to settle." "Already? You filed 5 days ago." "Deputy County Attorney called personally. Wants to meet next Tuesday." Marcus was quiet for a moment. "They're scared. This is good. But Camille, first settlement offers are always lowball. They'll try to make you go away cheap. Don't take the first offer." "What should I ask for?" "Everything in your prayer for relief. Money, policy changes, monitoring, training, the works. And make it clear that you won't sign a confidentiality agreement." "They'll never agree to that." "Maybe not. But we start high and negotiate down. Besides, you have leverage. The complaint is public record. The media will pick it up eventually. The longer this drags on, the worse they look." He was right. 3 days later, the Raleigh News and Observer ran a story. Law student files civil rights complaint against Durham County. A third-year Duke law student has filed a federal civil rights complaint alleging systematic harassment and discrimination at the Durham County Justice Center. The complaint names multiple courthouse employees and includes detailed documentation of security screening disparities and administrative obstruction. The student, who is representing a disabled client in an eviction case, claims she was subjected to prolonged secondary screenings, lost filings, and threats from courthouse security. Statistical analysis included in the complaint shows she was detained at security checkpoints 92% of the time over a 6-month period, compared to 0% for white attorneys during the same time frame. The story went viral in North Carolina legal circles. Social media erupted. Other attorneys, mostly women, mostly black and brown, started sharing their own stories of courthouse harassment. At Durham Courthouse. Access trended locally for 2 days. The county attorney's office issued another statement, defensive this time. Durham County maintains that all courthouse security procedures are applied uniformly and without regard to race or ethnicity. We look forward to presenting the full facts in court. But the damage was done. Public pressure was building. March 18th, settlement meeting. Marcus Chen drove down from Raleigh to meet Camille at Duke. Then they drove together to the county attorney's office in Durham. Jennifer Lowe met them in the lobby. Mid-40s, professionally dressed, carefully neutral expression. Ms. Booker, Mr. Chen, thank you for coming. She led them to a conference room. 4 people were already seated, an older man in a suit, likely the county attorney himself, a woman with a legal pad, paralegal, and 2 others Camille recognized from county government photos online. No Travis, no Sharon, no Elliot. The actual defendants weren't there, just lawyers and administrators. Jennifer made introductions. This is County Attorney Douglas Reed, Assistant County Attorney Sarah Mitchell, County Manager Patricia Vance, and HR Director Thomas Garrett. Everyone shook hands and sat down. Douglas Reed opened. Ms. Booker, we appreciate you taking the time to meet with us. Durham County takes your allegations seriously, and we want to explore whether there's a path to resolution that serves everyone's interests. Camille said nothing. Let him talk. We've conducted a preliminary internal review of the incidents described in your complaint. We've identified some areas where procedures could have been clearer, and we're committed to making improvements. What kind of improvements? Marcus asked. Enhanced training for courthouse security staff on unconscious bias and equal treatment. Clearer guidelines for when secondary screenings are warranted. Better documentation requirements for administrative decisions by the clerk's office. That's a start, Marcus said. What about the individual defendants? Douglas shifted slightly. Officer Mundy has been placed on administrative leave pending the outcome of the internal review. Ms. Pruitt has been reassigned to a non-public-facing role. Mr. Chandler... He paused. Mr. Chandler has requested a leave of absence to address personal matters. Camille's eyebrows rose. Elliot had requested leave? That meant the state bar complaint about his misrepresentation of case law was probably moving forward. And Judge Hargrove? She asked. Judge Hargrove is a member of the judiciary. We have no authority over him. However, we understand he's filed a disclosure with the North Carolina Judicial Standards Commission regarding his relationship with Judge Roland Booker. So they were all scrambling. Good. Let me be direct, Douglas continued. The county is prepared to offer a settlement, $25,000, confidential. You dismiss the complaint with prejudice, and we move forward. Marcus didn't even pause. No. I'm sorry? The answer is no. $25,000 doesn't begin to address the harm Ms. Booker suffered, or the systemic changes needed to prevent this from happening to others. What are you looking for? Marcus pulled out a copy of Camille's complaint and flipped to the prayer for relief. Everything listed here. $150,000 in compensatory damages, $500,000 in punitive damages. Policy reforms including independent monitoring of security practices, quarterly public reporting of screening demographics, mandatory anti-bias training, and a clear complaint process for courthouse visitors who experience discrimination. Douglas stopped himself. That's not realistic. Then we'll see you in court. Camille stood. Marcus followed her lead. Wait, Douglas said. Let's not be hasty. We can negotiate. Then negotiate, Marcus said. You have our number. When you're ready to make a serious offer, call us. They walked out. In the car, Camille exhaled. Was that too aggressive? Not even close. They opened at $25,000 with a confidentiality clause. That's an insult. They're hoping you're desperate enough to take it and go away quietly. So what happens now? Now they go back and panic. Realize we're serious. Come back with a better offer, probably in the next 48 hours. Marcus was wrong. The call came in 24 hours. Jennifer Lowe this time, not Douglas Reed. Ms. Booker, the county would like to continue settlement discussions. Would you and Mr. Chen be available for a call tomorrow? We can make ourselves available. The next day, conference call. Same players from the county side. Jennifer took the lead this time. We've reassessed our position. The county is prepared to offer $75,000, no confidentiality requirement. Officer Mundy will be terminated. Ms. Pruitt will be permanently reassigned. We'll implement the training programs and policy changes you've requested, with quarterly public reporting of security screening demographics. Marcus looked at Camille. She shook her head slightly. That's closer, Marcus said. But we still need independent monitoring. Someone outside the county reviewing compliance with the new policies. Otherwise, you'll just go back to business as usual once the media attention dies down. We can agree to monitoring, but it can't be open-ended. We'd propose a 12-month monitoring period. 18 months, Marcus countered, with the option to extend if compliance issues are identified. Silence on the other end. Muffled conversation. We can do 18 months, fixed term, no extension option. Marcus looked at Camille again. She considered it. Mundy terminated. No, wait. What does terminated mean? She asked. Fired or allowed to resign with benefits? More silence. Officer Mundy would resign, effective immediately. No further employment with Durham County in any capacity. Does he keep his pension? Union rules require that we can't take his pension for administrative violations, but he would not be eligible for rehire. So Travis would walk away with his pension intact. 20 years of service, 6 complaints ignored, pattern of harassment documented, and he'd still get to retire on the taxpayer's dime. What about Elliot Chandler? Camille asked. Mr. Chandler is being investigated by the state bar. That process is ongoing. We have no control over the outcome. And Judge Hargrove? Judge Hargrove has recused himself from all cases involving Duke Law clinical students. He's submitted a disclosure to the Judicial Standards Commission. Any further action is up to them. Translation. Hargrove would face no real consequences. Maybe a private reprimand, maybe nothing. Camille looked at the notes she'd been taking. 75,000. Mundy resigns. Sharon reassigned. Policy reforms. Monitoring for 18 months. Public reporting. It wasn't everything she wanted. Travis kept his pension. Hargrove stayed on the bench. Elliot might beat the state bar complaint, but it was something. More than most civil rights plaintiffs got. We need one more thing, she said. What's that? A public apology from Durham County, acknowledging that I was subjected to discriminatory treatment and that the county failed to prevent it. Long silence. We can issue a public statement acknowledging that our procedures fell short of the standards we expect and committing to do better. But we can't admit legal liability. That would expose us to— I don't need you to admit liability, Camille said. I need you to acknowledge that your employees treated me differently because of my race, and that you're taking steps to ensure it doesn't happen again. More muffled conversation. We can include language in the settlement agreement stating that Durham County acknowledges concerns about disparate treatment and is committed to ensuring equal access for all courthouse visitors regardless of race. We'll issue a press release with similar language. Marcus looked at Camille. Your call. She thought about Mrs. Hughes, still in her apartment, case still pending, but safe for now because Camille had fought for her. She thought about the other attorneys who'd reached out after the news story broke, the ones who'd experienced similar treatment but never filed complaints because they thought nothing would change. She thought about Travis Mundy's face when she handed him the complaint, Sharon Pruitt's panic, Elliot Chandler's stammering realization that he'd underestimated her completely. I'll take it, she said. But I want the settlement agreement to include specific policy details, no vague promises. Actual requirements with measurable outcomes. We can do that. And I want to approve the press release language before it goes out. Agreed. And Mr. Chandler's State Bar complaint. I want the county to cooperate fully with that investigation. No legal maneuvers to protect him. The State Bar investigation is independent. We can't interfere either way. Then don't interfere. Don't provide him with county legal representation. Don't fight subpoenas. Just let the process work. We can agree to that. Marcus pulled out his laptop. Let's draft the settlement terms now while we're all on the call. I want this in writing before anyone changes their mind. 3 hours later, they had a settlement agreement. 11 pages of terms. Payment: $75,000 to Camille Booker. Travis Mundy. Resignation: effective immediately, no rehire eligibility. Sharon Pruitt. Permanent reassignment to records archives. Written reprimand in personnel file. Policy changes: mandatory anti-bias training for all courthouse security and administrative staff annually. Written guidelines for secondary screenings requiring documented justification. Public reporting of security screening demographics quarterly. Independent monitor appointed for 18 months to review compliance. Clear complaint process for courthouse visitors with investigation requirements. Public acknowledgement: Durham County to issue press release. Acknowledging disparate treatment concerns and commitment to reform. No confidentiality. Settlement terms are public record. Elliot Chandler. County will not provide legal representation in state bar proceedings. Judge Hargrove. No county position but disclosure to judicial standards. Commission confirmed. Camille read it 3 times. Marcus reviewed every clause. This is a good settlement, he said quietly. Better than most. But not perfect. Nothing's ever perfect. But you changed things. Real, measurable things. And you kept your voice. No one's silencing you. If you've made it this far in Camille's journey, please hit subscribe. The ending is something you won't want to miss. The settlement was finalized 2 weeks later. Durham County issued the press release on April 2nd. Durham County reaches settlement in courthouse access case. Durham County has reached a settlement agreement with Camille Booker, a Duke law student who raised concerns about courthouse security and administrative procedures. While the county maintains that its employees acted in good faith, we acknowledge that procedural improvements are needed to ensure equal treatment for all courthouse visitors, regardless of race or background. As part of the settlement, Durham County is implementing comprehensive policy reforms, including enhanced training, clearer guidelines for security screenings, independent monitoring, and quarterly public reporting of security demographics. The county is committed to providing access to justice for all who seek it. We thank Ms. Booker for bringing these concerns to our attention and working with us to develop meaningful solutions. It wasn't everything Camille had wanted, but it was something. The money came through April 15th. $75,000, minus Marcus's attorney fees and costs. Camille netted $48,000. She used $20,000 to pay off her law school loans, gave $10,000 to Mrs. Hughes to help with her back rent and moving costs to a better apartment, put the rest in savings. Mrs. Hughes cried when Camille handed her the check. You didn't have to do this. You were willing to fight when everyone told you to give up. That mattered. This is just making sure you have a safe place to live while you keep fighting. What about your case? Did you win? Camille thought about that question. The Court of Appeals still hadn't ruled on the Hughes appeal. Recusal had delayed everything. Travis kept his pension. Hargrove kept his robe. Elliot was on leave but might beat the state bar complaint. I won enough, she said finally. April 20th. Camille received an email from the North Carolina Board of Law Examiners. Dear Ms. Booker, congratulations. You have successfully passed the North Carolina bar examination. Your score placed you in the 95th percentile. You are eligible for admission to the North Carolina State Bar upon completion of character and fitness review. She read it twice, then called her father. Dad, I passed the bar. I never doubted you would. 95th percentile? Yes, sir. Your mother would have been proud." His voice was thick with emotion. Her mother had died when Camille was 16. Breast cancer. She'd been a civil rights attorney in Charlotte. Would have loved this fight. "I know." "You still planning to do public defender work?" "That's the plan." "Good. They need people like you, people who don't back down." They talked for another 20 minutes. About the bar exam, about the settlement, about the complaint against Durham County. When they finally hung up, Camille felt lighter than she had in months. May 6th, swearing-in ceremony for new attorneys, North Carolina State Bar Building in Raleigh. 200 new lawyers taking the oath. Camille wore her navy suit, pearl earrings, professional, serious. Her father flew down from Richmond to administer her oath personally. Special permission from the state bar to have a family member perform the ceremony. They stood together at the front of the room, Judge Roland Booker in his federal robes, Camille in her suit. "Do you solemnly swear to support the Constitution of the United States and the Constitution of North Carolina, to be faithful and bear true allegiance to the state of North Carolina, and to the constitutional powers and authorities which are or may be established for the government thereof, to faithfully discharge the duties of an attorney according to the best of your ability, so help you God?" "I do." "Then, by the power vested in me by the state of North Carolina, I declare you admitted to the North Carolina State Bar. Congratulations, Attorney Booker." They shook hands, then hugged. Professor Washington was in the audience, grinning. Marcus Chen had come too, sitting in the back row. After the ceremony, they all went to dinner. Celebrated, toasted the new attorney. Marcus raised his glass. "To Camille, who taught us that sometimes the law actually works when you're brave enough to enforce it." "Hear, hear," Professor Washington added. But Camille's mind was already on what came next. June 1st, first day as an attorney at the Durham County Public Defender's Office. She'd accepted the position in April, turning down 3 private firms that had made offers after the settlement made news. Her office was small, shared with another new attorney. Metal desk, plastic chair, overflowing file cabinets, stack of case files waiting for her. Her first client was a 19-year-old black kid charged with misdemeanor trespassing. According to the police report, he'd been sitting on his own grandmother's front porch when a neighbor called 911 about a suspicious person. Camille read the file and smiled grimly. Same system, different day. But now she had tools, experience, a record of winning, and she wasn't a student anymore. July 15th. The North Carolina Court of Appeals finally issued its opinion in Hughes v. Greenfield Properties. 8 months after oral arguments. 4 months after the settlement. The opinion was 12 pages. Written by Judge Simmons. We reverse the trial court's denial of emergency relief. North Carolina General Statute Tier 4226 requires 30 days written notice for month-to-month residential tenancies. The landlord provided 3 days. This is a clear statutory violation. The tenant's lease waiver of notice rights is void under Brown v. Keener as against public policy. The trial court abused its discretion by denying the TRO without findings of fact and by scheduling the hearing after the eviction date, rendering any potential relief meaningless. We remand for proceedings consistent with this opinion. Camille called Mrs. Hughes. We won. What does that mean? It means the law is on our side. It means other tenants facing the same situation can use this case. It means Greenfield Properties can't evict people with 3 days' notice anymore. Will I get to stay in my apartment? The case is going back to the trial court for a new hearing, but the Court of Appeals has already said the landlord violated the law. You should be able to negotiate a settlement that lets you stay. Because of you. Because you were willing to fight. 3 days later, Greenfield Properties settled. Mrs. Hughes got to stay in her apartment at her old rent. The company agreed to bring the unit up to full ADA compliance within 90 days. Small victory, but it mattered. August brought news about the individual defendants. Travis Mundy. Resigned as agreed. Took a job as a security consultant for a private firm in Raleigh, living on his pension. No criminal charges filed. Sharon Pruitt. Still in the records archives. counting down to retirement. Bitter but quiet. Elliot Chandler. The state bar complaint was still pending. He'd hired a prominent legal ethics attorney to defend him. The process could take another year or more. He'd returned to work at the county attorney's office, but was keeping a low profile. Judge Maxwell Hargrove, still on the bench. The Judicial Standards Commission had issued a private letter of caution about failure to disclose conflicts. No public discipline, no suspension, just a note in his file that no one would ever see. The system had bent, but it hadn't broken. September 12th, exactly 1 year since Camille's first visit to Durham County Justice Center. She had a hearing scheduled, a preliminary hearing for one of her public defender clients. She walked through security, different guard, young guy, maybe mid-20s. He looked at her professionally. "Good morning, ma'am. How can I help you?" "Attorney Booker. I have a hearing in Courtroom 3A. "Have a good day, ma'am." She walked through the metal detector. 45 seconds total. The clerk's office had a new chief clerk. Sharon's replacement was a woman in her 30s named Angela Foster. Efficient, professional, polite. "Attorney Booker, here to file?" "Yes. Notice of appearance for State versus Williams." Angela stamped it immediately. "Anything else?" "That's all. Thank you." "You're welcome. Have a good day." Changes. Small ones, but real. In Courtroom 3A, a different judge presided. Judge Hargrove had been reassigned to civil matters. Criminal cases went to other judges now. Camille handled her preliminary hearing, got her client's bail reduced, set a trial date. Walking out, she passed a young black woman in the hallway. Law student, based on the Duke clinical program folder she carried. First year, probably. Looking nervous. "Excuse me," the woman said. "Are you Attorney Booker?" "I am. I'm Jasmine Wallace, first-year clinical student. I just wanted to say, I read about your case, what you did. It made a difference. I filed my first motion here yesterday, and security waved me through. The clerk processed my filing in 10 minutes. I don't know if that's because of your lawsuit, but thank you." Camille smiled. "You're welcome. And Jasmine? Document everything. Every interaction. Every delay. Every time something feels wrong. Because the system still protects itself. But if you document it, you can fight it." "I will. Thank you." Jasmine walked toward the courtrooms. Camille watched her go. Small victories. Incremental change. Not transformation. Not revolution. But progress. That night, Camille sat at her kitchen table with her laptop open. She'd started writing an article for the North Carolina Law Review. Gatekeeping Justice. How Courthouse Access Barriers Violate Constitutional Rights. 43 pages so far. Analysis of courthouse security practices across North Carolina. Statistical patterns of disparate treatment. Legal framework for challenging systemic discrimination. The article would be published in December. Already, 3 federal cases had cited her complaint as an example of documented courthouse access violations. Change came slowly, but it came. October brought an unexpected email. From Elliot Chandler, Ms. Booker, I wanted to reach out to you directly, which I probably should have done months ago. I owe you an apology. When you first appeared in my courtroom, I made assumptions about who you were and what you were capable of based on your age and appearance. Those assumptions were wrong, and they led me to treat you in ways that were dismissive and, frankly, discriminatory. I also made a significant professional error in citing Booker v. North Carolina without thoroughly researching the author or carefully reading Judge Booker's concurrence. That error was inexcusable for an attorney with my experience. I've used the past 6 months to reflect on my practice and my biases. The state bar investigation is ongoing, and I accept whatever outcome that process produces. I don't expect your forgiveness, but I wanted you to know that you were right to file your complaint, and that the changes Durham County is implementing are necessary and long overdue. I hope your career as an attorney is as successful as your advocacy as a student has been. Respectfully, Elliot Chandler. Camille read it twice. It could be genuine remorse, or it could be a strategic move to help with his state bar defense, show contrition, Take responsibility, demonstrate growth. She'd probably never know which. She didn't respond to the email, just saved it to her files and moved on. November 3rd, Marcus Chen called. Camille, I wanted to give you a heads up. I've been contacted by attorneys from 3 other North Carolina counties. They have clients, mostly black and brown women, who've experienced similar courthouse harassment. They want to know if you'd be willing to consult on their cases. As an expert witness? More like a consultant. Share your documentation methods. Explain what worked in your case. Help them build their complaints. Will it help them win? It might, or at least make the counties take them seriously and settle instead of fighting. Then yes, I'll help. There's something else. The ACLU wants to do a broader investigation of courthouse access practices statewide. We're talking about filing a pattern and practice lawsuit against multiple counties. Would you be willing to be a named plaintiff? Camille thought about it. More litigation, more publicity, more time away from her public defender clients, but also more change, systemic, structural change instead of just one county. Let me think about it. Send me the details. I will. And Camille, what you did matters. You know that, right? Some days I feel like I barely made a dent. You made more than a dent. You showed that it's possible to fight back and win. That matters more than you think. December brought one final development. Camille received a thick envelope from the Durham County Courthouse. Inside, the quarterly security screening report required by the settlement agreement. She opened it and read the statistics. Q3 2025 security screening data. Total visitors, 14,732. Secondary screenings, 412, 2.8%. Breakdown by race. White visitors, 8,841. Secondary screenings, 127, 1.4%. Black visitors, 4,223. Secondary screenings, 198, 4.7%. Hispanic visitors, 1,102. Secondary screenings, 61, 5.5%. Other, unknown, 566. Secondary screenings, 26, 4.6%. The disparity had decreased, not eliminated. Black visitors were still screened at more than 3 times the rate of white visitors. Hispanic visitors even higher. But it was better than the 92% she'd experienced. Better than the complete absence of accountability that existed before. Progress. Attached to the report was a note from the Independent Monitor. Durham County has made significant improvements in security screening protocols. Training has been implemented. Documentation requirements are being followed. However, disparities persist and require continued attention. I recommend extending the monitoring period beyond the initial 18 months. The county hadn't responded to that recommendation yet. Camille sent the report to Marcus. They're going to fight the extension, he said when he called. They'll argue they've complied with the settlement terms and monitoring should end as agreed. What do I do? You could file a motion to enforce the settlement agreement and request the extension, but that means more litigation. Or you let the 18 months run out and see what happens. If the disparities get worse again, you have grounds for a new complaint. So I just wait and hope they keep doing the right thing? Welcome to systemic reform. It's frustrating, slow, imperfect. But you built a foundation. The policies exist now. The data is public. If they backslide, people will notice. It wasn't satisfying, but it was realistic. December 15th, Law Review article published. Gatekeeping Justice. How Courthouse Access Barriers Violate Constitutional Rights hit the North Carolina Law Review. Within a week, it had been downloaded 20,400 times. 2 federal judges cited it in opinions. 3 law schools added it to their civil rights syllabi. Camille's phone rang constantly. Interview requests from legal publications. Speaking invitations from bar associations. Job offers from civil rights organizations. She turned down most of them. Stayed focused on her public defender work. But she did accept one invitation. to speak at Duke Law School's annual Civil Rights Symposium. March 4th, 2026. Exactly 1 year after the oral arguments that had changed everything. Camille stood at a podium in the Duke Law Auditorium. 200 students, professors, and practicing attorneys in the audience. A year ago today, I stood in the North Carolina Court of Appeals and argued that my client deserved equal treatment under the law. It seems like a simple proposition, but achieving it required 6 months of documentation, a federal civil rights complaint, and a battle against a system designed to protect itself. She clicked to the next slide. Statistics from her case. 23 incidents of discriminatory security screening, 92% detention rate, 15 minutes average delay. This is what systemic discrimination looks like when you document it. Next slide. The settlement terms. We didn't win everything. The officer who harassed me kept his pension. The judge who showed bias stayed on the bench. The city attorney who lied to the appellate court is still practicing law. But we changed the policies, created accountability, made the next person's fight a little bit easier. Final slide. The quarterly screening data showing reduced but persistent disparities. This is what victory looks like in civil rights work. Not perfect, not complete, but better than it was, and that's worth fighting for. Afterwards, students swarmed her with questions. Jasmine Wallace, the first year she'd met in the courthouse, pushed through the crowd. "Attorney Booker, I wanted to show you something." She held up her phone. Email from the Durham County Clerk's office. "Dear Ms. Wallace, we received your filing today at 2:47 p.m. and have scheduled your hearing for next Tuesday at 9:00 a.m. Please let us know if this timing presents any conflicts. Regards, Angela Foster, Chief Clerk." Jasmine was grinning. Professional, efficient, no delays, no games. I think it's because they know we're watching now. Camille smiled. Keep watching, and keep documenting. That night, Camille returned to her apartment, opened her laptop, checked her email. One new message. Subject line, Re. Booker v. Durham County. Final monitoring report. She opened it. The independent monitor's 18-month review was complete. Final recommendation. Durham County had substantially complied with settlement terms. Monitoring period should end as scheduled. However, public reporting should continue indefinitely to maintain accountability. The county had agreed to continue quarterly reporting for an additional 12 months, then annually after that. Not everything she wanted, but something. She closed the laptop and looked at the framed photograph on her desk. Her mother, wearing her bar admission robes, smiling. "We're doing the work, Mom. It's slow, it's frustrating, but we're doing it." Her phone buzzed. Text from Marcus Chen. "Just got word. Elliot Chandler accepted a public reprimand from the state bar and completed ethics training. No suspension. He's back practicing full-time." So Elliot had survived. Slap on the wrist, mandatory class, back to work. The system protecting itself again. But then another text from Marcus. "But 3 attorneys have cited your complaint in new courthouse access cases, and the ACLU's pattern and practice investigation is moving forward. 2 more counties have agreed to policy reforms without litigation." Ripples, not waves, but ripples. Camille put her phone down and pulled up the file for her next public defender case. A young woman charged with shoplifting. Single mother. Working 2 jobs. Stole diapers and formula because she couldn't afford them. The system would grind her down if no one fought for her. Camille started drafting the motion to suppress. The search had been illegal. The officer had exceeded his authority. The evidence should be excluded. She knew the arguments, knew the cases, knew how to fight, and she would keep fighting. The next morning, Camille received one final piece of mail. A thick envelope, no return address, postmarked from Durham. Inside, a single sheet of paper, printed, anonymous. "Attorney Booker, you don't know me, but I work at Durham County Courthouse. I've worked here for 12 years. I've seen a lot of attorneys come and go. Most of them play the game. Accept the way things work. Don't make waves. You made waves, and I'm grateful. Because of your lawsuit, security protocols changed. Training happened. People started paying attention. And yesterday, something happened that never would have happened before. A young black man came through security. The guard started to send him to secondary screening. His supervisor stopped him, said, "We need documented justification now. Do you have a specific reason?" The guard didn't. The young man walked through in 30 seconds. That happened because you fought, because you documented, because you refused to accept the way things were. "I can't sign this. I still work here, but I wanted you to know. It mattered. Thank you." Camille read it 3 times, then filed it carefully in her records. That afternoon, she had a hearing at Durham County Courthouse. She walked through security. The guard was professional, 45 seconds. She filed her motion at the clerk's office. Angela processed it immediately. She appeared before a different judge, not Hargrove. The judge listened to her arguments, ruled from the bench, granted her motion to suppress. Her client wouldn't go to jail for stealing diapers. Small victory. Walking out, Camille passed the wall where the security screening statute was posted. North Carolina General Statute, BR 143422.3. The same statute she'd read aloud to Travis Mundy a year and a half ago. All persons entering courthouse facilities shall be subject to security screening without regard to race, color, or national origin. The law had been there all along. It just needed someone willing to enforce it. That night, Camille opened her laptop one final time, checked her courthouse access folder. 104 pages of documentation, 23 incidents, 87 exhibits, statistical analysis, video evidence, emails, transcripts, the complete record of a fight. She closed the folder and opened a new one, labeled it Future Cases, because the fight wasn't over. It never was. But she was ready. She'd learned how to document, how to fight, how to win. And she'd learned that sometimes, not always, but sometimes, the law actually worked when you were brave enough to enforce it. Her phone buzzed. Email from the North Carolina Court of Appeals. Subject: Mandate issued. Hughes v. Greenfield Properties. She opened it. The mandate had been issued. The case was officially over. Mrs. Hughes could stay in her apartment. Greenfield Properties had to comply with the notice statute. The precedent was set. Victory. Incomplete. Imperfect. Hard-won. But victory nonetheless. Camille closed her laptop. Tomorrow she had 3 client meetings, 2 hearings, and a motion to draft. The work continued. But tonight, just for a moment, she let herself acknowledge what she'd accomplished. She'd walked into a courthouse as a law student with no connections, or so they thought. She'd faced harassment, obstruction, and threats. She'd documented everything. She'd fought back. And she'd changed the system. Not completely, not permanently, but enough that the next person would have an easier path. Enough that Jasmine Wallace could walk through security without being detained. Enough that anonymous courthouse employees felt hope instead of resignation. Enough that attorneys across North Carolina were citing her case and filing their own complaints. Enough. She turned off the lights and went to bed. Tomorrow the fight would continue, but tonight she'd earned rest. Outside her window, Durham slept. The courthouse stood dark and quiet. Inside those walls, new policies existed now. Training requirements, monitoring systems, accountability measures. Not perfect, but better. And in the morning, when the courthouse opened again, when security screened visitors and clerks processed filings and judges heard cases, things would be just a little bit more equal than they'd been before, because Camille Booker had refused to accept the way things were. And sometimes, not always, but sometimes, that was enough to change them. Attorney Camille Booker sat in her office at the Durham Civil Rights Law Center, reviewing a new courthouse access complaint filed by a young Latina attorney in Wake County. The pattern was familiar. Secondary screenings, lost filings, delayed hearings. But something was different this time. The attorney had documentation. 23 incidents, statistical analysis, video evidence. She'd read Camille's law review article, followed the methodology, built an undeniable case. On Camille's wall hung a framed letter from the North Carolina ACLU recognizing her work. Beside it, a photograph of Mrs. Hughes at her apartment, still living independently, still fighting her own battles. And next to that, a news clipping. 5th County agrees to courthouse access reforms following Booker precedent. The system hadn't transformed. Travis Mundy still collected his pension. Judge Hargrove still wore his robes. Elliot Chandler still practiced law, though more carefully now. Incomplete justice. Frustrating reality. But Durham County's quarterly reports showed screening disparities cut by 67%. 8 other North Carolina counties had adopted similar monitoring programs. 14 attorneys had cited her case in civil rights complaints. 3 had won settlements. The ripples continued spreading. Camille's phone rang. A law student facing courthouse harassment in Charlotte. Same pattern, different county. "Document everything," Camille said. "Every date, every time, every witness. Build the record they can't deny." She hung up and returned to the Wake County complaint. The fight was never over. The system still protected itself. But now, others knew how to fight back. And that knowledge, passed from one attorney to the next, case by case, complaint by complaint, that was how real change happened. Not overnight, not perfectly, but inevitably.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.